And now here's Adrian Snyman. He, of course, has been acquitted. Julius Malema. Mr. Malema? Mr. Malema? Mr. Mdantsane, man. Let's speak to this man. Mr. Malema? Mr. Malema? Mr. Malema? Adrian, you've been acquitted. If I can't get to Malema, let's get Adrian. And of course, Leon Matei saying, yes, I tried, but okay. Mdantsane will remember how you blocked us there. We'll remember Mdantsane blocking us there from Julius when we were right there, Sam Kellen.
Are they really trying to minimize him speaking to the media at all? They're trying to not hamper there are any chances of trying to persuade Magistrate Lynette Olivier in any form of any way. They're trying to keep him as quiet as possible. Even yesterday, you saw he was very timid. He was very short in his address. Yes. Very calculative. No attacks. The only restrained. The only punch went to AfriForum. Anyone else very restrained. No political speeches of this is a political persecution against me. Whoever wants is going for the kill. It was, if there needs be, we are going to go to the apex court in the land. We're going to appeal this particular judgment. We are ready for any eventuality, but I am going home, and I'm going home just like all of you. I'm going nowhere else. So he was very restrained in everything he has had to say. They are prepared on all fronts. They are prepared legally. They are prepared politically. They are very quiet on certain political talk. There's no rhetoric. It's only trying to say, let's appease the judge, let's not fight with her, but let's disagree with her within the prescripts of the law and respect her court.
Mdantsane, you wouldn't let us speak to Julius Malema, so you're going to speak. Is that what you are trying to do? Are you trying to make sure that you minimize what Julius Malema is saying outside of the court here?
No, we've never been apologetic about what we say, especially about this magistrate, and we've always been honest that we will speak out about it. You heard our advocate yesterday when he touched AfriForum. The magistrate just went haywire and started to want to remove people from court. So we are not apologetic, and our president is a vocal person, and they need to understand he's a vocal and straightforward person and speaks the truth, and it will be done all the time. We cannot be massaging feelings of a magistrate that we can all see who she's defending.
He looked subdued yesterday, you look subdued today, so I would imagine you are expecting a less than favorable outcome by the looks on your faces.
No, why are you saying on our faces? Check, the fighters are jovial. The family was jovial. We are jovial. We've been expecting the worst from this magistrate, and we're ready for it. We've always said we're going to appeal because we do believe that there is a sober judge out there that will reverse this mess that's going to happen if it happens.
So we know that you are expecting the worst because you've dotted your legal teams all over the country to deal with whatever eventuality is to come.
We have dotted teams. Fighters are at each and every court in the country. Our team is already waiting at Grahamstown, and I hope your team is waiting there also.
We are ready. We are ready.
Stream it live because we're waiting. We're always ready. We're combat ready. We're ready.
What is the essence of your deputy president and the legal team being in Makhanda? What is the thrust? What is the nub of that particular issue of being ready to stream what is happening at Makhanda? Because there seems to be a particular attention and focus and particular attention on Makhanda.
Did you hear anything?
When you are facing such a judge, a magistrate, you have to be ready for anything that will happen.
So you didn't hear anything?
We are planted everywhere. No, I cannot not hear anything when I'm the spokesperson.
This is exactly what I'm getting at. You must have heard something which prompted that course of action.
We are planted everywhere. Safe to say we are planted everywhere. We've deployed our fighters everywhere in the country for any eventuality that happens. We believe in the justice system, and we are a peaceful party. That you can rest assured. We are a peaceful party. We'll respect the law as we've been respecting the law for the past 8 years. I can go now.
Last one.
Yesterday, Advocate Tembakan Dugaitobi says that any adverse judgment, a custodial sentence, may inflame the members and supporters of the economic freedom fighters. We've seen the country go up in flames in the incarceration of former President Zuma in KwaZulu-Natal, parts of Gauteng and parts of Mpumalanga. Should there be an adverse judgment, an adverse sentence within this court here today, how can South Africans rely on the EFF to make sure that their country does not burn?
Magic word, may. We had a national shutdown. No building was burnt. When we shut down the whole country, no building was. We are a peaceful party. Really, believe me, we're very peaceful.
So no violence expected here today?
No violence expected. We are a peaceful party. If you bring violence on us, I see they've beefed up a lot of SAPs. If they provoke us, we cannot lay back and just allow to be provoked. But if you are provoked and you bring violence onto us, expect violence. But we're a peaceful organization.
But what does that mean if they provoke us? What does if they provoke us?
Provocation is provocation, Sakina. In any form or way, provocation is provocation.
Who are the lawyers in Makanda? Who are the lawyers in Makanda? Who are the lawyers in Makanda?
Who's in Makanda for EFF? Who's in Makanda? Who's in Makanda? And of course, she's running away, Mdantsane, but we tried.
I'm not running away, I'm being abused. You guys are abusing me.
We're trying to get answers. We're trying to get answers. So who are the lawyers in Makanda?
You're abusing me. No comment is no comment, right? Look, guys, we have lawyers and fighters everywhere in the country. So it shouldn't be that you want to focus on a special case. Why are you not asking me who are the lawyers in Grahamstown?
Who are they?
I'm asking you who are the lawyers in Grahamstown.
All right, we tried. Mdantsane there, Samkele, and of course, you know, as she says, they will not. They're not anticipating. They do not have any intentions of anything violent here today, unless she says they are provoked.
Indeed, they are saying that they are essentially they will not have any violence unless if they are provoked. But at this point in time, they will be peaceful. They will not do anything wrong. I can hear that there is some relative information that is coming through on what is going to transpire. At any moment from now, the magistrate will walk in, Sakina.
Yes, because she said 9 a.m. It's 9 a.m. And of course, we do have our camera station inside the court as well. And maybe we can take you in there to have a look with our colleagues, making sure that we have eyes, ears in and around this entire precinct and further afield as far as Makanda as well. We have a team deployed there to make sure that we cover every aspect of what is unfolding here. Should this judgment of sentencing not go in Julius Malema's way, his legal teams are ready in Makanda to petition the High Court in Makanda. But if that is not enough, they are also ready in Johannesburg in petition constitutional court if need be. So that but of course the focus now shifts to the court. Of course, Magistrate Toinette Willefeer. And Samkele, you wanted to say something before we go in?
The most interesting thing today is dressed in black, the red tie of the economic movement, which adds that nuance of we will not tire until we get what we believe in. We will fight right until the end. Whenever he's faced with adversity, particularly of a movement that he leads, he always puts on and dons that red tie of the economic emancipation movement, Sakina.
So from the outside here at the KuGompo Magistrates Court, let's take you inside to the SABC team that's stationed there.
All right, Sakina, thank you very much for that. Reporter, SABC News reporter anchor Sakina Kamwendo and senior politics reporter Samkele Maseko. There you can see live visuals of Julius Malema inside the court there in the city of KuGompo. SABC team quite well prepared for this broadcast, as you've heard from my two colleagues on the ground, that we do have reporters stationed across the country where the economic freedom fighters, as indicated, they have stationed their lawyers ready to file an application. And of course, what would that application be? We've heard they would apply for leave to appeal. And in South Africa, you then ask, what becomes the law? If perhaps he were to be sentenced, given a custodial sentence in this respect, what does the law say about an appeal? Does filing an application for leave to appeal stay the execution of a specific sentence in this respect? Yes, in South Africa it does. If you file an application for leave to appeal or noting an appeal, generally automatically stays, or in better terms suspends the execution and operation of a judgment. That's why they're standing guard today to quickly file, should it be that there is a custodial sentence.
want to organize myself as well, Mr. Secretary. My name is
Please ensure that all cell phones are switched off or placed on silent. Are we in record? Are we in record? Thank
Yes.
you. Case number Regional Court 44620B, State versus Julius Malema. The date is the 16th of April 2026. The parties are as follows. Presiding Officer Mrs. T. Olivier, Public Prosecutor Advocate J. Caesar, Defense Advocate L. Houdes SC, Advocate T. Nukaitobi SC, instructed by Ian Levitt attorneys. Our clerk is Ms. Mkameni. Usually today I'm accompanied by my boss, the Director of Public Prosecutions, Mr. Barry Madolo. I will have at least one assistant today. That will be Your Worship, the matter was set down today for sentencing.
Thank you. Thank you. Thank you. Okay. Let me get comfortable. Sorry, Advocate, is the state ready to proceed and to note sentence? State ready to note sentence.
Yes, please. Yes, God
No
bless you.
still photos, please, by the media or anyone. Advocate Otis, defense ready.
We are all present and ready to proceed.
Thank you. Advocate Nkugaitobi.
Indeed, Your Worship.
Thank you. This is the one I need. I don't need these ones. Let me just ensure our record is there. Okay. Then the court is ready to proceed with sentence in the matter of Julius Malema, hereinafter referred to as the accused. Mr. Malema, please be seated for the duration of the sentence. As judgment, the court can leave no stone unturned, so we'll arrive and I will tell you when to stand up. Thank you. Just as courtesy then, for the state appears Advocate Caesar and the defense being Advocate Odes and Advocate Nkugaitobi as instructed by Ian Levitt attorneys. The others were mentioned and acknowledged on record yesterday. And as stated, the court will proceed with sentence. The accused before court was convicted of 5 counts. Count 1, contravening Section 3 of Act 60 of 2000 of the Firearms Control Act, read with the provisions of Section 1, 103, 117, 120, in brackets 1A and 121, read with column 1 of Schedule 4 of the said Act, being the unlawful possession of a firearm. Count 2, contravening Section 90 of the Firearms Control Act 60 of 2000, read with the same provisions mentioned in Count 1, being the unlawful possession of ammunition. Count 3, contravening section 120 subsection 7 of the Firearm Controls Act 60 of 2000, being the unlawful discharge of a firearm in a built-up area. Count 4, contravening section 120 subsection 3C of the Firearms Control Act 60 of 2000, being the unlawful failure to take reasonable precautions to avoid danger to a person or property in circumstances where it created a risk to the safety or property of the general public. Count 5, contravening section 120, subsection 3B of the Firearms Control Act 60 of 2000, reckless endangerment to a person or property. The applicable penalty clauses as invoked by the state and in terms of section 121 of the Firearms Control Act 60 of 2000, with specific reference to column 1 and schedule 4 of the said act. For record purposes, the court will place them on record. In respect of count 1, it is a maximum of 15 years imprisonment. In respect of count 2, a maximum of 15 years imprisonment. In respect of count 3, a maximum term of 5 years imprisonment. In respect of count 4, a maximum term of 5 years imprisonment. In respect of count 5, a maximum term of 5 years imprisonment. In essence, the various sections invoked by the state, as read with each count, means the following. I deem it necessary to state all this 103s. I will give a brief explanation. Section 103 of the Firearms Control Act 60 of 2000 deals with the crimes and offences giving rise to unfitness inquiries by courts after conviction or sentence of any of the offences as mentioned. Section 121 of the Firearms Control Act states that any person convicted of contravening any of the sections mentioned in column 1 of Schedule 4 may be sentenced to a fine or to imprisonment for a period not should be exceeding the period mentioned in column 2 of the said schedule. Section 120 of Act 60 of 2000, as invoked in each count, refers to the offences, penalties, and the administrative fines applicable. Section 151 of the Firearms Control Act 60 of 2000 states that despite any law to the contrary, any magistrate's court has jurisdiction to impose any penalty provided for in terms of the said act. The court deemed it fit to explain the relevant section invoked by the state in each count for clarity purposes only. It should be noted, and it is well known by this stage, that the provisions of Section 51, subsection 2 of the Criminal Law Amendment Act 105 of 1997 is not applicable in the matter before court, as the section was not invoked by the state in the charge sheet at the commencement of the trial. Therefore, the accused was not warned in terms of the above-mentioned section. It merely means that instead of a minimum sentence of 15 years applicable in respect of counts 1 and 2, the state invoked the penalty clause as contained in column 1 of Schedule 4 of the said act, which prescribes a maximum penalty of 15 years imprisonment. I trust this explanation is understood and the reasons as to why the minimum sentence is not applicable, and that the defense does not need to show compelling or substantial circumstances for the court to warrant a deviation of the minimum sentence legislation. Plainly stated is one of some with a minimum of 15 years, the second with a maximum term of 15 years imprisonment. With regards to the maximum sentence, the normal principles followed by courts when sentence is considered is therefore applicable. The above charges relate to the incident relating to the EFF, or the Economic Freedom Fighters' 5th birthday celebration held at Sisa Dukashe Stadium, Mdantsane, on the 28th of July 2018. The incident led to the arrest of the accused and his subsequent appearance in court on 27 November 2019. Thereafter, as a result of the COVID pandemic which the country faced, the accused appeared for the first time in person before this court, and you'll need to bear with me here, on the 29th of March 2021. on which date a trial date was then secured. The trial date for the matter to proceed was 27 August 2021. However, the erstwhile state advocate was ill, and she had notified parties beforehand that the matter may not proceed, and a postponement for trial was arranged in the absence of the accused and the defense team, and the trial date then secured being 28 February 2022. On the said date, Advocate Sisa appeared on behalf of the state, and the case formally proceeded, or the trial proceeded, on 1 March 2022 for the week up to the 4th of March 2022, being for 4 days. From there, it was postponed to 5 September 2022 for the week. However, and this is not criticism at all, because the matter was dealt with very professionally, as the defense had indicated a prior commitment and could not honor the week of September. And in the absence of all parties, a date for further evidence was then arranged, being 30 January up to the 3rd of February 2023, and it proceeded for 5 consecutive days. 1 September 2023 was the following dates, up to 14 September 2023, that was 4 days, and the state case was closed on the 14th of September, meaning it was a total of 13 court days that was spent on the state's case after hearing plus minus 19 state witnesses and 3 applications brought by the defense in that period. I would say 2, because the 174 I'll deal with now. As from the 14th of September, the matter was postponed to the 20th of September 2023, whereby a Section 174 application was brought by the defense, and the ruling by court on the 19th of October 2023 was then ruled in terms of Section 174, and that ended the state matter, the 3 applications, and it lasted a total of 15 court days. During the week of 18 June 2024 to 20 June 2024, after 3 consecutive days, the defense case was closed, and on 1 November 2024, the date was secured, including the date of 9 December 2024, was set aside for address on merits. However, due to myself having sustained an injury, I indicated to the state and the defense that there's a possibility that I may not be present on the 1st of November, which I happen to be, and they had elected, correctly so, the safest option was to proceed on the 9th of December 2024 for address on merits. Indeed, then it had proceeded on the 9th of December 2024, continued, where am I now? 2024. Thereafter, 29, yes, the defense case was then closed. It continued 29 September 2025, 30 September 2025, and 1 October 2025 for the extremely long judgment delivered by this court. I still shudder. Thereafter, it was postponed to 23 January 2026 for the pre-sentence report, which was then, the court heard the evidence of Ms. Jessie Thompson, and from that date postponed to yesterday, 15 April, and I will summarize the proceedings that took place yesterday, and then hence we find ourselves here today, 16 April 2026. In total, I think what felt like an extremely long time and which has been discussed as 7.5 years, it's clear having to combine 6, 7 defense counsel, state, court was available, nonetheless was quite a task, and it amounted to the matter proceeding plus minus twice a year on 4.5 days per session. So the trial lasted, I would say, plus minus 31 days. Okay. The court has decided to, in this instance, instead of starting by placing on record the provisions or principles traditionally taken into account by any sentencing court, to deal with the mitigating heads of argument placed on record by the defense, thereafter with the address by the state, and then the court will proceed in calmness with the principles applicable before sentence. Okay. First then, with regards to the heads of the defense, and the same will apply to the state, the court does not deem it necessary to repeat what has been placed before court. The defense had submitted detailed written heads of argument in advance and then addressed the court yesterday, being the 15th of April 2026. Therefore, the court has indeed had sufficient time prior to yesterday to read, peruse, and after yesterday's arguments to digest what has been presented to court by the defense. I will start off by, it goes without saying that in this instance, the defense had requested that or stated that there is no other sentence which is appropriate save for a non-custodial sentence, and I will continue with that at a later stage. Therefore, the court has had the opportunity to visit and peruse all the case law as quoted in great detail by the defense and has given it the full attention that it deserves. The case law is attached, although in 3 pages, to the heads of argument filed by the defense. It will be a moot exercise to repeat all the cases listed, unless you would require me to do so. The same may be said regarding the pre-sentence report. It was submitted to court on the 23rd of January 2026, and Ms. Thompson had read the report into the record verbatim. Therefore, there is no need to repeat the contents, as it is reflected and recorded and forms part of the written transcription and record of this court. The court therefore has had more than sufficient time to peruse and to take note of the contents of the said report, and combined with the evidence in chief, the cross-examination that followed, including the re-examination and clarity questions by court, it is clear that the pre-sentence report has been noted fully, and I will deal with the recommendations shortly. The contents are noted and accepted, therefore, as evidence on behalf of the accused person. The court will, however, refer to a few points that may require a response from court at a later stage. The court has indeed scrutinized the case law quoted by the defense in paragraphs 25, 26, and 27, and the court reiterates the importance of the findings made regarding the role of the courts in upholding the Constitution, wherein the state is described as the role model for our society. This court is in total agreement with the submissions that let me just open this file. This court is therefore in total agreement with the submissions by the defense that a court's impartiality must never be open to reasonable doubt. For its moral authority, without it, would cease to enjoy legitimate public confidence and ready compliance with its decisions by all, and that our courts are to defend and uphold the Constitution and the rights entrenched therein. More so when the deprivation of an individual's liberty or freedom may be affected. It is indeed a core right to be enjoyed by all. Paragraphs 28, 29, 30, 31, and 32 sets out all the examples of sentences imposed by our courts as stipulated in the heads of arguments. There is no need to repeat the paragraphs, it was read into the record. What is clear is that there are a variety of sentences imposed by our courts regarding the possession of firearms over the years, pertaining to semi-automatic rifles, pistols, revolvers, including offences that were committed using firearms. What is to be distinguished in these matters are notably, as raised by the defence and as per the pre-sentence report and viva voce evidence of Ms. Thompson, the circumstances under which the offences were committed, including the purpose thereof, the duration, and as highlighted by the defence, the issue whether any harm or injuries emanated from the offences. Further, that the ammunition was fired had been described as celebratory shots, and that there is no case law pertaining to the facts relating to the matter before court, more so based on the term used being, and I quote, celebratory shots. A further submission by the defence on record mentions that should any court consider a custodial sentence as appropriate in the matter before the court, it will be seen as the accused is singled out for unduly harsh punishment. The defence concedes the offences are serious and that the case law differs as the defence had pointed out in the case law on record, and surely again emphasised that the duration, circumstances, including the lack of harm to person or property, should be considered, that indeed it is the accused's right not to show any remorse. It has no impact on sentence. Further, that the accused regrets the perception that his actions created. When dealing with the pre-sentence report, it may appear as if it is a repetition on the side of the court, but I need to mention, because the points raised by Ms. Thompson indeed overlaps with the heads of the defence drafted on behalf of the accused. In addition to the heads, I will add the following: that the accused person's personality type was assessed, and the reason for doing so was to offer context to his conduct and potential behavior expectations. Ms. Thompson had regard to the personal circumstances of the accused, his background, education, and career. Further, that the accused continues to assert his innocence. Nevertheless, however, he regrets the incident. The report deals with the evaluation of actual and potential harm because of the offences, the seriousness of the offences, as well as, once again, the purpose of the offences. And in recommendations, Ms. Thompson proposed that a monetary fine as a sentence option should be applicable, and describes the fine as a sentence option which will reflect the gravity of the offence. Further suggestions by Ms. Thompson were to restrict the accused person from obtaining a firearm license for a specified period, and that he should be ordered to make a financial contribution to Gun Free South Africa, an NGO focusing on reducing gun violence in South Africa. She also testified, and it is contained in the said report, that the firing of the celebratory shots had been deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. She continues to state that the planning does not suggest that the activity was undertaken with the intent to commit an offence or endanger lives or cause damage to property. And as mentioned in paragraph 17.3 of the defence heads of argument now, that the careless and reckless discharge of firearms in a public setting conveys an inappropriate message about gun safety and responsible firearm use. Now, in this instance, it was mentioned that particularly when a prominent leader exhibits such conduct. The court agrees with this submission. Further, the court agrees with the submission by the defense that the actions of individuals in positions of influence are likely to be emulated by their supporters, thereby warranting what is perceived to be more severe assessment of their behavior. However, the defense then proceeded to state that the behavior of the accused indeed once again reiterated did not cause harm to person, property, and the court was then requested to consider that the said firearm in question was returned to the lawful custodian promptly, and that the celebratory shots were fired in a very short space of time, and that the accused had not loaded the ammunition personally. Further, that the accused had obtained the firearm from an individual most likely affiliated with tactical security services, and some of the controversial statements during, how will I say, reply by replying counsel. Okay. That in essence were the points raised by the defense and the social worker, Ms. Thompson. And as I've stated yesterday, reading the paper gives new meaning when one hears the oral arguments in court. It gives more perspective, insight, to see and hear the tone of how a statement is made has a different impact on a court as a piece of paper which is words. So therefore it was important for the court yesterday to pause when it did and then retire to indeed consider sentence. Those were the aspects as stated, dealt with by the defense, and I will now deal with the aggravating circumstances as indicated or raised by Advocate Sisa on behalf of the state. The state submitted that they request that the court should consider a custodial sentence in this matter for the following reasons: that the incident was planned and it was deliberate and executed with precision, and that the submission is made based on the accused's own evidence. Also on this aspect, I would say we will deal with the merits once we reach that point. Further, that it was a collective decision made by the EFF's leadership, and that it was planned to entertain the crowd to ensure that the crowd is not bored during the event. In this regard, the state relies on the submissions based on the evidence of the accused that, I quote, everything was perfect and calculated and designed to be the way it was done, unquote. Therefore, it was not an act based on a lapse of judgment. These submissions was then substantiated based on the case law by the defense and similarly quoted then by the state. The state and the defense basically, in fact, relied on the same case law pertaining to this matter. The state continued to submit that on the ballistic evidence presented, it was established that to discharge a semi-automatic rifle in a built-up area densely populated using a .223 Remington round was fired, and that retains lethal kinetic energy on descent. The potential for mass injury or harm was real, it was foreseeable and scientifically established. Mdantsane is a residential area. The state alluded to the fact that the accused's position as a public leader and role model is, I would say, a fact. Submissions made thereafter by the state requested the court to consider that the accused is a member of parliament and also the president of a political party, admired and followed by millions of South African citizens, and arguing that it is aggravating and not mitigating as per the defense submissions in this regard. The state referred to the video footage, which was accepted by court. That again, I will say, deals with the merits. It was clear what footage was admitted by court and what was not admitted. The state alleged that the accused clearly lacked insight and accountability and sought political justification as an excuse, thereby undermining the public confidence in the administration of justice. These submissions was followed by the concerns the state raised regarding the evidence and pre-sentence report drafted by Ms. Thompson and the findings by the witness and the submissions by the defense regarding the brevity of the possession and that it was not accidental, and that the discharge of a semi-automatic rifle cannot be described as benign, and since the risk of injury or harm is extreme. Celebratory purposes in this regard, the state submitted that this type may not be condoned, this type of discharge may not be condoned, and that the law makes no provision for such actions. The state then embarked on the discussion and submissions regarding the case law, which was placed on record. I am not going to repeat, it has been noted. The only difference I may add by the side is that although the state and the defense relied on the same case law, it is clear that the state will use the portions which is beneficial to them, and the defense would obviously use the portions which is beneficial to the defense. And ultimately, at the end, the court is required to bring them together. The fact that the state further continued that the fact that there appears to be no harm or injury caused as a result of the commission of the offense is conceded by the state, however disagrees with the defense regarding the weight that it should be attached by court. The Parliament criminalized the creation of risk, not that there is a requirement of an actual harm or injury, but the actual act itself. The state continued to highlight three, which they termed, I'll say, pointers, that being the imperative of equality before the law. I'm not going to elaborate on that point at this stage. The imperative of proportionality and the imperative of deterrence. Those were the three highlighted by the state. And concluded its submissions by referring to State v. Zinn and pressing I'm trying to also expedite the sentence, just a minute. The state then submitted that the proposed sentences will give proper effect to all the principles and objectives set out in State v. Zinn with safety, and it will satisfy the constitutional mandate of equal treatment before the law, and it will serve the legitimate and pressing interests of a society that has the right to expect its leaders to obey the same laws they are elected to uphold. Now, the court will proceed with the principles traditionally taken into account by sentencing court. It is a well-known fact that sentence proceedings are the most difficult part of any court proceedings. It does not only affect the accused person, but also the family of the offender, including the society, that being the public welfare, safety concern, and the interest of society. It is also known that a court is obliged to consider the normal aspects of sentence traditionally taken into account before imposing sentence. These aspects being the accused is indeed a first offender before court and has no outstanding or pending criminal matters. It also includes the possibility of reoffending. I'm not going to elaborate on that aspect. It was done by the defense. It is noted as one of the principles to be taken into account. It also includes loss of employment. In this instance, the case law is clear that should sentence result in the loss of employment, it should be noted that crime is an inevitable consequence of crime, or loss of employment is an inevitable consequence of crime. The court is also obliged to consider the family of the offender. This fact was fully discussed in the pre-sentence report submitted by Ms. Thompson, who testified in mitigation of sentence. On this score, I also think it is appropriate to highlight, I do not intend to discuss the depth of the pre-sentence report, as was submitted by the defense in the heads yesterday, orally, that I accept it was an invasion of the accused's personal space. It could never be seen as an easy exercise. And we heard that evidence of Ms. Thompson, I think, in excess of 5 hours on the 23rd of January. And I think that in itself was surely not a pleasant experience. So I'm merely going to highlight how I have highlighted the content and then the family, etc. I do not intend to rehash personal circumstances which has been dealt with or heard. The other aspect that the court needs to consider is the state of health of the offender, and the court was informed that the accused does not suffer of any medical or physical ailments as per the report. Youthfulness, it is so that the accused is still relatively young. And most importantly, the position of trust. This is one pointer that the court will return to. It requires full reasoning by court, and I will do so during the process of sentencing. The further aspect is that the prevalence and seriousness of the offense. This is an aspect the court cannot shy away from today, but also requires full reasoning, and the court will do so during the proceeding of the sentence. Those two aspects. The above are but a few pointers traditionally taken into account by courts before sentence, and some require a detailed explanation by courts. It is well known that the ends of justice are four in number, being deterring, preventative, reformative, and retributive in its nature. It, however, consists of 5 important functions. It should act as a general deterrent. It should also act as a specific deterrent. It should also, or it must enable the possibility of correction. And it must be protective of society. And it must further also serve society's desire that crime be adequately addressed by courts. It is in the public interest that punishment be meted out fairly and without the measure of excessiveness that would mark it as being merciless and unacceptably unfair. The court is mindful that neither the call for true punishment and revenge, neither the cry for understanding must be given undue weight. The ends of justice, as mentioned already, must be given due regard when determining sentence. And it is required that a court should strive to accomplish and arrive at a judicious counterbalance between the elements mentioned and ensure that one element is not unduly accentuated at the expense or exclusion of any other element. It has been often stated in various case law that the sentence imposed should fit the offender as well as the crime. It must be fair to society and blended with a measure of mercy according to the circumstances of each matter. True mercy, therefore, has nothing in common with soft weakness or maudlin sympathy with the offender, since it is a crucial element of our justice system in its own right. It is also not an element that mere lip service is paid to, but indeed a sound factor that each court must consider and which must clearly reflect in the sentence imposed. However, courts are required not to strive as stated for severity, but neither on the other hand surrender to misplaced pity, and should not flinch from firmness where it is called for, and that a court should be strict enough to ensure that the objects of punishment are adequately furthered, and indicating thereby that crime will be effectively punished. Having said that, this court is well aware that a court should approach its task with a humane understanding of human behavior and frailties. Just a minute. I've been talking a lot, just a minute. I think at this stage, while we are still proceeding calmly, I'm going to deal with general concerns when reaching sentence regarding matters of this nature. Thereafter, the court will deal with the reply to the offense before court or the matter before court. It should be noted that crime is inconsistent with the rule of law and the fundamental value of our Constitution. It undermines the constitutional commitment to human dignity and further the achievement of equality, including the advancement of human rights and freedom. Crime is therefore the antithesis of an open, accountable, democratic government as required by our Constitution. Chaskelson P. in South African Association of Personal Injury Lawyers versus Heath and others, 2001, SA 1883, Constitutional Court, 2001, in brackets 1, states that, I quote, elected office bearers and officials in the public service have become one of the most serious threats to our country's well-being, and that is to state the obvious. Although the mentioned case deals with corruption and crimes of dishonesty, it is still relevant to the crime in general, and as far as it relates to public office bearers, as the impact and consequence pertaining to the matter before court today remains the same, if not worse. It is clear that if crimes are allowed to go unchecked and unpunished, it poses a serious threat to our democratic state. Crime in South Africa is ever escalating, and it appears to be an acceptable way of life in our country, this being a situation the courts cannot allow or tolerate. The incidents may well be characterized as a pandemic that needs to be recognized as such and requires concerted and drastic efforts to combat it. It is regrettable that too often in South Africa, African courts, the so-called, and I quote, non-violent crimes have been visited with lenient sentences due to the classification of no violence, and that perpetrators of these offences are seen as not to be truly criminals or even prison material due to their ostensibly respectable careers and lifestyles. The above-mentioned case stated on record speaks about dishonesty. However, this court will dare to say that it does not merely refer to related offences such as fraud, etc., but it includes the dishonest character of an individual, indicating that such conduct entails gross breaches of trust. At the beginning of the sentence, the court mentioned the element of trust and that a court should consider before imposing a sentence, and based on the facts of the matter before court, including the circumstances in which the offences were committed, it shouts of the breach of trust and is of great concern to this court today. The accused is in a position of trust and elected as such by the members of society. The conduct of the accused and the effect of his actions and the impact of the conviction on the accused combined all reflects, contrary to what is expected from our Constitution, the complete absence of accountability and breach of trust by the accused person before court. I'm going to try and summarize the response to the defense submissions as follows. It must be noted, and the accused confirmed, that the event was planned. Emphasis on the word event was planned, and that it was a unique established tradition planning an event. Firstly, I stand corrected on this aspect, but what I should have clarified is the following, that this was, according to the knowledge of this court, the fifth birthday celebration was the first of its kind. I do not understand the wording of it was a well-established tradition. We heard that the 10th birthday celebration, what the main feature was, but whether it was an established tradition at the 5th birthday celebration, I'm not aware. As a result, it is a great concern to this court that an event was planned and that what appears to be the unique feature of the event ended up in the commission of an offense or offenses. Surely this can never ring true. As per the submissions, the court is asked to consider that the accused had planned the event, and then it goes a step further, because contrary to the view of the defense and the view of the state, today it is clear that the planning included that the accused will possess or take possession of a semi-automatic rifle, fire a .223 Remington bullet into the air, thereby causing possible harm to person or property in a built-up area. That it is now called a celebratory shots, That is sugarcoating. Nothing more, nothing less. The facts found by court during its judgment, and this is not merits, these are facts. I'm going from memory. It was the evidence considered was that the accused had decided that the event was planned by the leadership. All decisions were made by the leadership. So there can be no doubt that you are saying the unique feature of the event was committing 5 offenses. That is the bottom line. Clearly, planning of this nature is in contrast with the law. How can a court of law consider that the actions of the accused did not intend or did not entail the intention to commit an offense? It is not it is not the thinking of the court, it is the facts before court, because that is what happened. It wasn't, as the state correctly stated, an act of an impulsive act. It wasn't, as a result of the case law we heard, an act of passion. It wasn't anger. It was the event of the evening. And therein lies the difference. It should take considerable planning for an event of that magnitude, and I'm deviating from my written judgment, of that magnitude, that as to how, when, and exactly at what time you will take possession of the firearm, where you will fire it from, at which point we all know then, Mr. Snyman, you returned the firearm to Mr. Snyman. That finding was made by court. The court did not find it was handed to you by Mr. Snyman. That is what I'll say in that regard. So that, to reason any otherwise is nonsensical. This is a decision that a person made to possess a semi-automatic rifle unlawfully, and including the decision then to proceed and fire the said rifle in a built-up area in a crowded stadium. The decision to break the law has been made, and it was made with the approval of the accused person and the leadership. Since it's confirmed that this was the future planned for the event, it clearly indicates that the accused had known it was unlawful. He knew that it may cause harm to persons or property. He knew all the above, and it yet proceeded to possess the rifle and to fire the shot in celebration of the 5th birthday celebrations of the economic freedom fighters. Always knowing when this was being planned, arranging this special feature that it is in contravention of the law. And that this decision was made long before the actual event. Such acts can never be condoned by this court in any instance. The court cannot dismiss these actions planned by the accused as mere celebratory shots, and further justify the commission of crime under the pretense that it was celebratory shots. much has been said yesterday regarding other offenders who've committed acts of this nature, worse, who have has not been brought before a court of law. This court is not in a position to answer for those matters. Safe to say, I trust that surely the long arm of the law would reach and bring those offenders or suspected offenders before court. This court can only reply and answer for the matter before it, not for what has been said was done by Mr. A to Z or Miss A to Z. I'm unable to do so. My focus is on this matter solely. With regards to, yes, as I say, as far as it pertains to individuals who had committed the same offences and had not yet been brought before a court of law, should this type of reasoning be condoned, it is clearly not conducive to the interest of society, and the courts are required to act accordingly. And that is as much as I can say regarding the offenders who are still to be brought before courts. The other aspect that is aggravating in this matter and which needs to be mentioned is the astronomical financial impact this matter has had on the taxpayers' pockets or at the taxpayers' expenses. By saying that, please, that is not laid at the foot of the accused person solely, not at all. It was your right to take this matter on trial. I'm saying merely that a trial of this magnitude involved tremendous human or manpower. If we look at the ballistic side of this matter alone, the transport of firearms from KZN to Quebeca and back, the ballistic unit resources and equipment, preparation, SABC. The tragedy is that this matter has also led to so many people that did not have access to this court on several days where this matter proceeded. Mothers could not approach the court for maintenance. They could not reach inside. Grandmothers could not come to the offices to apply for foster care or guardians, appointment, adoptions, domestic violence. Those people did not have access. And that is tragic. These are members of the community this court services on a daily basis. They wake up, as you very well know, all of us very well know, by 3 a.m., by 4 p.m., those little kids are dressed, washed, and they walk to court. And yet they cannot reach the entrance of this court for the help that they need. What has transpired is indeed sad. It's a sad day for justice if this is what bringing a matter of this nature to court results in the impact on the interest of society. And as I've stated, the courts must protect the interest of society. Not only did it affect those people I've mentioned, courts adjourned early. Our court rolls are overcrowded beyond comprehension. Inmates had to be returned to correctional services, leading to the extension of the overcrowding of prisons or correctional facilities. Witnesses who traveled from far, who lost a family member, let us say in a murder incident, they did not get closure on a specific day which was allocated to them for their matter to be heard. They have to come back. So yes, this matter indeed is sad because it has an immense tragic effect on the administration of justice and the very interest of society that is to be served by justice and its staff and courts. And that is not overemphasizing, that is a fact and a reality. The only aspect I'll mention with regards to the time frame of the actual possession of the rifle, yes, indeed, I agree it was very short. I agree with the submissions of the defense that yes, the charge sheet mentions 1.223 Remington cartridge, correct. I agree that the charge sheet mentions 1 SPA 249. Therefore, the court is limited to what you have been charged for, and that is what I'm dealing with. Nothing more. Safe to say then, on what the court has already alluded to, the commission of these offences are not insignificant, and the impact thereof remains the same. Whether it was done in less than a minute, the impact remains the same. Now, this is a difficult matter to raise because it was alluded by the defense that should a custodial sentence be imposed by court, it will show that the accused is singled out to endure a harsh sentence. To this, the only reply from court is, it is not the court who has singled out the accused person. He had done so all by himself, not the court. In the light of the position that he holds as the CIC of a political party with massive support, it's not the court who had singled out the accused person. The fact remains there is a significant amount of accountability on the accused, and on this regard I'll add the following, that please remember, it is not a political party who has been convicted here. It is not the economic freedom fighters that have been convicted. It is a person, an individual, who so happens to be the CIC of a political party. Nothing more, nothing less. It's not the party, it's an individual, and that is how it is perceived. And while I'm on the topic which is uncomfortable for everyone, let us continue with this political trend that is followed. This court heard, as I've stated, plus minus 19 witnesses. Not a single witness testified before this court testified regarding any political facts, or that is not facts before court. The evidence or political agenda was raised by the accused, which is your right, but those are not facts as part of the state's case. And that's where it ends. A court of law and politics do not blend. The two do not collide. Judiciary stays in its lane, politician stays in the lane. The easiest way to explain this is, I think the minds of a jurist and the minds of a politician do not function on the same frequency at all. Hence, A court is expected to remain independent, dispense with justice without fear, favor, or prejudice, and that is the duty of this court. The rest is of no interest, only the law. Just a minute. On this topic, I'll end off by saying, at all times, the judiciary, including the justice system, will never be intimidated by any politically charged utterances or parties. There is no room in a court of law dealing with a criminal offense for the court to enter into politics at all. Okay, just need to find my rhythm as well here. Right. What is apparent then is that people of this country are speaking as one. Crime is reaching astronomical proportions, and the courts are required to do all in its power to combat the situation and to ensure that all would-be offenders or offenders who are still to be brought before justice faces the full arm of justice. And surely if this is not done or goes unchecked, as I've stated, it will result in the perception that crime is an inevitable consequence of life in South Africa. It must further be noted, as much as the rights of the accused has been emphasized, and correctly so, as it is enshrined in our Constitution, members of society too enjoy rights, the same rights as enshrined in our Constitution. These rights are not one-sided and enjoyed by all. I'm about to end off. I just want to briefly refer to our engagement yesterday in the oral submissions by the state and the defense regarding the two case laws submitted, one by the defense and the other by Advocate Sisa. Just want to get to the relevant part. Yes. Okay. My gracious. The matter submitted by the state being Romeo Janssen and the state, case number CANR 220/18, delivered by D. Van Zyl, then DJP, and by the defense, that of the Malundana case, case number CC 20/2024, delivered by Brooks J. Now, in this instance, it was interesting to read both. And what is abundantly clear is that in the matter presented, the Malundana case, the facts are completely opposite as the ones we are dealing with today. In the matter submitted, the Malundana matter, was a gentleman of 62 years old who had, after a very long period of time, secured employment as a security officer protecting a school, which led to him firing a handmade firearm. The difference in that matter, which the judges considered as sentence and mitigation of sentence, is the accused there had pleaded guilty. He had also spent a period of time incarcerated, 4 months in custody before. Further, he was also a first offender. He had assisted the victims at the scene, and he himself had called the police to come and assist. He had also contributed to the costs of the family who suffered in the incident. That is the set of facts unique to that matter. Now, what is interesting in the Janssen matter, counsel argued yesterday that the matter cannot be of assistance to the court. I disagree on that aspect. Indeed, it was. Because I think it was said that he had previous convictions, Janssen. But when you read the actual judgment, the judge states clearly that the accused was treated as a first offender despite having previous convictions. So that is not relevant. That was, he said, and he was found to be, or having been in possession only. There wasn't a crime that was committed on the day he was arrested with the firearm. And then interestingly, after being asked by the defense that all people be treated equal, it was submitted that Janssen is a gangster, therefore a member of Fat Boys, and therefore sentence of custodial sentence is in order. I failed to see the reasoning and the rationale behind that, but what is evident and clear after discussion of all the cases submitted by the state and the defense, in the view of this court, each case is unique. Every person is equal in law. What does equal mean in my view? That the court should ensure that accused rights to a fair trial is protected and that it applies equally to every individual who appears before a court of law. Sentences, we have this contradiction and variety because, as I've stated, each set of circumstances and facts are unique. If we take, without disrespecting a gangster would, we cannot say for gangsters, right, there's a sentence of 5 years. For politicians, it should be 6 years. For the homeless person, it's 10 years. No. It's done in its totality. And unfortunately, the accountability on a public office bearer is a lot more. It weighs heavy than that of the regular South African person. So by saying that, that doesn't mean you are not treated equally or the accused is not treated equally. That is not what equality, in my view, pertains. Just a minute. Nearly done, just a minute, please.
Your Worship, if I may at this stage, I'm so sorry about this. I need an urgent comfort break, Your Worship. I've been sitting here since 7:30 this morning, Your Worship. I'm so sorry about that.
I'm going to single you out, Advocate Sisa.
Yes, Your Worship. I tried my best to not
So
ask.
I was perusing the file to end off, but okay, can we then say, I'm sorry for this then, But instead of 5 minutes, it's a large crowd. So we say this is then the tea adjournment. We come back, we continue then thereafter. I'm sorry for that. No, Advocate Nkwadobishe, I cannot. Just now we all drown when that man cannot. So, please, I'm going to just a minute. Sorry.
Correct. What time, Your Worship? What time? What time are we coming back?
25 past. Can we all agree, due to the amount of people who may also need the facilities and who need to go out and come back in, it's 11:15 in order?
Yes, please, Your Worship.
I'm even asking the gallery sufficient time to come back and continue. Yeah.
scenario to come out of the court behind us today?
Indeed, they are ready for the worst case scenario to come out of the court behind us today. In fact, I was just speaking with some EFF Central Command team members who are essentially saying they are readying themselves for Makhanda at this point in time. And whatever will transpire in Makhanda, they are readying themselves for that particular aspect. Their minds are no longer here. They know that the worst is going to come from it. For instance, if we listen to the magistrate is speaking about women not being able to access the courts, members of the EFF blockading the entrance to the courts, all sorts of sundry reasons throughout this particular reading of handing down this particular sentence to the EFF leader, Julius Malema. So they're already anticipating it's going to be a long, protracted day here in the courts, at the magistrate's court, which will ultimately move in the afternoon to the Makhanda High Court, which will ultimately mean there will be whatever they will be applying for will be on an urgent basis, maybe heard this evening, and ultimately judgment on that passed tomorrow. And in between that, the question was from one of them, where will the CIC be in all of these legal processes?
And of course, that is the thing here, Samkele Maseko. For all intents and purposes, the operation for the economic freedom fighters, at least from those that we've managed to engage with, it has moved from KuGompo to Makhanda at this point. That is where they are focusing their attention on right now. And speaking of, we also have a team, because one of the members earlier said to us, do you have a team ready there? Because this is where they are expecting things to move. But also, to your point, what they are anticipating, they were anticipating that this morning's proceedings would be a lot speedier so that there could be a conclusion. But there has been, of course, that theory that says that they want to humiliate their CIC. So therefore, they want to see him spend some time in a jail cell.
Indeed, they've got that perception that the state is doing everything in order to humiliate Julius Malema, particularly if we look at the number of cases that have taken place here in the Eastern Cape, the Omotoso case, how the state has been embarrassed within that particular case, and basically around the cross-examination with the magistrate at that time saying, if this is the cross-examination of the state, then I don't know what cross-examination basically is. So the state is going to want to use this particular case of Julius Malema to show its might, to make sure that he's made an example of to society. Hence the EFF is readying for life in Makhanda now later on today, as opposed to being concentrated here at this KuGompo magistrate's court. So essentially for them, the ball has shifted. It's now moved to Makhanda. They may still physically be here, but their mindset is already on the other side.
And I guess that is the next battleground. This is what they are waiting for. Time becomes of the essence then, just in terms of how quickly we get through proceedings here. Because listening to the tone and what is being said by the magistrate, she does seem to be leading to that worst case scenario that the EFF is expecting.
She's seemingly leaning to that worst case scenario. If you look at the scenario she's painting out and drawing out and reading of a judgment, or sentence judgment, but also time is of the essence. Well, they are on tea right now. If we are not careful, they will be on lunch. Then ultimately it will be the afternoon. What time do they launch at the High Court? And what time will a judge be available to hear an urgent application in the High Court in Makhanda? So you've got to look at those variables as well. And what time will the state be able to respond to those papers of the defendants here?
And Mfundo, you would have listened to what the judge was reading in aggravation as well. And the point that Samkelo picked on right at the onset, that of course of other members of the public. So to our right there, you would see other members of the public coming to the courts. And as you can see behind us, many members supporting the EFF also here. But of course, those people, as she read out, this case has come at great cost to the taxpayer of South Africa, to the state, preventing other people from making use of the services of the court. But one could argue that that is not necessarily the problem of the accused, that the court should have dealt with that matter in their planning.
The court should have dealt with the logistics of the on this part. For instance, Julius Malema is not the first high-profile politician to go with crowds to a court. Former President Zuma, since time immemorial, since I was in high school in 2005, has been going to courts with an entourage. I remember at the CR Swat Magistrates Court in Durban, there used to be large crowds outside that court. You go to the Pietermaritzburg Regional High Court, there are always large crowds for former President Zuma. Julius Malema himself going through the on-point engineers trial, accompanied by the late Mama Winnie Madikizela Mandela, was always around large crowds within his court cases of corruption on-point engineers. So it's not the first time that politicians go to courts with large crowds. The courts must adequately prepare the logistics for the appearance of these leaders and for ordinary South Africans, for an ordinary Gogo, Martina, to be able to access the courts in order to be able to get her maintenance.
And of course, Mfundo, at this point we are competing with the sound coming from the stage to our left, also addressing the crowd that is gathered here in support of Julius Malema. And that is, of course, what we are also hearing at the moment during this tea break, just trying to give some sort of update to the supporters who may not have been able to hear all of the proceedings inside court.
Indeed, I can just see Lutando Chungu, the national chair of the EFF, and some family members of Julius Malema. They've just gone out. They are heading towards the vehicle on that other end. Not sure where they are going. I do know that the Treasurer General has also left and went to Makanda. So it essentially tells you that the high delegation of EFF leadership is now splitting. The Secretary General is remaining behind. The Treasurer General and the Deputy President are in Makanda. You can see the National Chair now who's leaving. You don't know where she's going at this point in time. That just tells you that there's a shift. Even Marshal Dlamini addressing these supporters now, saying and continuously emphasizing that we're not leaving here today without the Commander-in-Chief, and they will do everything necessary to make sure that he goes home, spends time with his wife and his children today.
And they have been, Mfundo, some of the members of the leadership of the EFF asking us whether our flights were booked for today or tomorrow, because apparently we might miss something if our flights were booked for a time too early. But of course, it is all about the court processes, about what is likely to unfold. But as you said, Sam, time is of the essence. And whilst we're on that tea break, I would imagine the team inside communicating with the other teams stationed elsewhere in Makanda, in Johannesburg, just to get a sense and take the pulse of where things are at the moment.
The most intriguing part is how coy and mum they've been on who's the legal representative.
Yes,
in Makanda.
we asked that.
That they are very coy. We've asked several people. They are very coy in the term. Mdantsane did not want to say on the record. Vuyani Pambo did not want to say. Sinawo Tambo did not want to say. In fact, I was in the vehicle with some EFF Central Command team members right now, just before I came up, and like, guys, what's happening? Who's your legal representatives in Makanda? They were very coy. Say, Sam, you will see. Just relax on that one. Just know that there is a team there who will tell you when the time is ready. So it just tells you the seriousness of how they are taking this particular answer, because ultimately, when judgment is handed down, they will try appeal here. If they can't, they must activate Makanda. If they can't activate Makanda, there is a team also in Johannesburg who's ready to take any legal action that needs to be done if necessary. And they've also, interestingly, have presence in all of the high courts in other provinces. I saw in Mpumalanga there's a presence at the Nelspruit Mbombela High Court. There is presence in Johannesburg and other parts of other high courts.
They've covered all the bases.
They've covered all the bases. Even in Limpopo, in Polokwane, where Julius Malema hails from, in Sishiko, there is a presence as well and around Zone 2.
So legally, we know that they are ready for any and every eventuality, but I keep emphasizing it doesn't start today. It didn't start yesterday. One got that sense on the 23rd of January when we were here that they were ready to proceed to the next part of this court case. And of course, they were already at that point ready for an appeal to be lodged. So this, in effect, for them is just prolonging the inevitable.
It is prolonging the inevitable. They will definitely appeal. They've said it on, Julius Malema said it on the record even yesterday on the podium addressing these members and supporters. He said that they are even going to go to the apex court in the land on this particular issue, offer this judgment by the magistrate. Olifir, in essence, they are anticipating the worst, but one of the most interesting factors if you're listening to the reasoning of the judge, she brought in the stature of Julius Malema, that he is a member of parliament, he's a leader of a political party.
She's been emphasizing that point.
Emphasizing that point and saying that
And equality before the law.
Equality before the law, and that in most instances when a political leader does something that is devoid of the law, he is bound to influence his supporters to do the same as he does. And that just tells you of where she is leaning towards, which brought about what we've been saying, that the state will want to make an example of him by throwing the rule book to him, who is one of the lawmakers of this country.
She tried to re-emphasize the point again that this is not a politically motivated case. And this is, of course, something that Advocate Toby dealt with yesterday when the judge, when Magistrate Olafir tried to say that, no, that is not within the purview of what we are dealing with now. And Advocate Toby showed her in the papers, for which she took a moment to, she asked to just read through that it is, in fact, within the purview of this court.
One of the interesting things, and in South African politics, many political leaders, when they find themselves in trouble, they always cry political foul, political persecution against them. And it's time immemorial. Jacob Zuma, Jackie Slebi, many others whom have subsequently had to go through the legal processes of the country, have said this is a politically motivated case against me in order to stop me from getting to whatever political destination. Sekgobela Magashule went through the same, saying the same amount of words. But ultimately it is their actions that lead them to these processes. And it's Julius Malema's unfortunate actions that led him here today and opened up a gap for every forum to come in and exploit. Whether it's political or not, that's a debate for political
100%.
players. But it is a legal matter that was influenced by politics.
100%. But you can't get away from the criminal matter. And that is what is being foregrounded now.
Yeah.
That in the final analysis, there was a crime that occurred, and this is what he has been found guilty of.
That is essentially what he's been found guilty of. It is about 4 charges. It is 4 charges.
Unlawful possession of a firearm,
unlawful possession firearm, unlawful possession of ammunition,
discharging a firearm in a built-up area. And of course, the final one was reckless endangerment.
Reckless endangerment in a built-up environment for persons and property. And that is essentially what transpired at the Sisa Dukashe Stadium of the of the 5th anniversary of the EFF. Interestingly, I was there at that stadium.
Yes.
I was there when that gun was fired in the evening of that particular night at the Sisa Dukashe Stadium in 2018.
You know about the video too.
Well, I don't know about the video.
That was used in evidence.
Evidently, we did put out that video of Julius Malema firing that firearm, which led to this particular case being here. Well, it was in my previous life, but it was work.
So yes, involved in more ways than one, Samkele Maseko, in terms of the video evidence that was ultimately used, which of course, as I'm looking behind you, I see Kirsten McLeod, who's the spokesperson for Adrian Snyman. And Adrian Snyman initially was, of course, co-accused with Julius Malema, who had subsequently been acquitted on all charges. And of course, this is something that we see the defense is going to obviously lean on in their appeal, among other things. That, and also we heard from Adrian Snyman, spokesperson, that they are now suing the state for malicious prosecution in that case.
Interestingly, yes, that will be one of the instances where Adrian Snyman is suing the state, but Advocate Toby touched on it yesterday in mitigation, that the state has handed back the weapon that Julius Malema is found guilty of discharging and illegally having ammunition for at the Sisa Dukashe Stadium. That has been returned to TSS security.
Before the
conclusion of this case, which means that going to Makanda, they will use the same similar arguments Advocate Toby has been advancing within this particular court in the appeal of this particular judgment, saying, no, you have the gun, the firearm that has been returned.
That was brought by somebody.
The ballistics have not yet been given to the legal team of Julius Malema and to this particular court, whereas the ballistics report of this particular firearm that was discharged on this particular night at the Sisa Dukashe Stadium. Those are some of the arguments that they will be advancing at the Makhanda High Court when they appeal this particular judgment.
And we heard, of course, the magistrate Toinette Olivier invoke that particular point in a different way here this morning, Mfundo, where she says that it cost the state a great deal of money and resources getting all of those ballistics reports, transporting that weapon from KZN here to the Eastern Cape. And she invoked that as part of the immense cost that this particular case has come at for the state.
That just tells you how Toinette Olivier, the magistrate, takes this case serious and how the state wants a conviction on this particular matter. And it just gives you the amount of resources being spent. Even here, you've got a chopper that has been here for the past 2 days.
Yes.
It is not cheap to fly a chopper. There is public order policing that has been increased. The state from all fronts is prepared on this case. The NPA on all fronts is prepared for the eventuality of a custodial sentence against the EFF leader.
And Mfundo, we're going to leave it there for now. I would imagine that it's about time for the proceedings inside the court to get underway again, but it's back to you, Mfundo.
All right, Sakina. The proceedings that you have been seeing in court, or the visuals from inside court, you would have seen a bit earlier on. There also seem to be fighters there. That is Mpumalanga, where SABC News reporter Nhlamulu Mabasa is stationed. Of course, the fighters there being led by their chair, Colin Sedibe. We'll take you to the other provinces where the EFF supporters are stationed and monitoring the sentencing proceedings, because one would assume all of them want to hear from themselves what becomes the outcome of this case that is 8 years in the making. As my colleagues were indicating there, that a number of points having been highlighted by Magistrate Toinette Olivier, again almost laying the foundation for what is to come. Some are of the view that what we're hearing now is her laying the foundation for possibly some sort of a custodial sentence. But also, given the weight of this case, one would think whatever the outcome, be it custodial sentence, suspended sentence, where he's just issued with a fine, whatever the outcome, most certainly there's been a lot of interest. This case has garnered interest where one would assume that a magistrate, a presiding officer that has to oversee or preside over such a matter would be under immense pressure. So most certainly such a judgment would be one that takes an inordinate amount of time, where you must preface that judgment by taking us through everything that has been stated and even your thoughts. As we've heard, she wanted to dispense with the arguments or suggestions that there was political motivation in this respect. She's also wanted to dispense with the argument that possibly he was just being singled out, going on to state that she believed it was the conduct of the accused that would have singled himself out. You can see there on those visuals Julius Malema almost gesturing for Mdantsane, that's his former bodyguard, to come to him. Most certainly remains a man that has been quite close to Julius Malema, even through the days of the ANC Youth League. Mdantsane, they're speaking to him. I want to take us to Mpumalanga now, where our reporter Nhlamulu Mabasa is monitoring the gathering by the economic freedom fighters in Mpumalanga, where they continue to monitor the sentencing proceedings. A very good morning to you, Nhlamulu. The fighters of Colin Sedibe, they gathered as well, wanting to hear for themselves what becomes the sentence today for their leader. Talk us through what's been happening there and what is the sentiment of those gathered there.
We are back on record then for resumption of RC 446 of 2020, and I will proceed where we left off. Just a minute. All right. I will then proceed and in summary, just add the following before pronouncing the sentence, is that we should also keep in mind the magnitude of the offense that the accused has been convicted of. We've heard daily or weekly of children playing in their front yards in the street who are caught in crossfire, random shots fired, killing people. It's just the first time that we hear it's being called celebratory shots. And in essence, the accused, all as stated, are equal before law. But in your instance, it cannot be said that you are not accountable due to the position you find yourself in. You are accountable to members or citizens of this country, to your followers, to the youth. And that accountability stems from your position. And that is where I'm going to end this. You may please stand up. Not the court only. I'm sorry. Maybe I should be clear. Okay. Sorry for that. All right. After careful consideration, and I can assure you I have done so, free of any interference, this judgment or sentence is the sentence of this court and this court alone. In respect of count 1, you are sentenced to a period of 5 years imprisonment. In respect of count 2, you are sentenced to a period of 2 years imprisonment. In respect of count 3, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 4, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 5, you are sentenced to pay a fine of 20,000 rand or to undergo 6 months imprisonment. In terms of Section 280, subsection 2 of Act 51 of 1977, the court orders that the sentence imposed in respect of counts 2, 3, 4, and 5 run concurrent with the sentence imposed in respect of count 1. You may be seated. Thank you.
Your Worship, I have instruction to proceed with an application for leave to appeal in terms of Section 3091 and 3091B.
May we, Advocate Odo, sorry, not to interrupt you, may we just deal with the Section 103 inquiry and then we can proceed to that part? I assume you are ready for that part as soon as we've dealt with the 103 inquiry.
Yes, Your Worship, and for bail pending the outcome of the appeal.
Certainly.
Thank you.
Okay. Let me just find my notes here. Just as a brief explanation to unless it's not clear, the next step of the sentence is that the court is obliged to deal with the provisions of Section 103, subsection 1 of Act 60 of 2000, meaning that the determination of unfitness, as I've explained in the beginning of the sentence, should not be made separately before sentencing, as information relevant to such fitness may emerge during the process of mitigation or circumstances. And the inquiry in terms of Section 103(1) Act 60 of 2000, since in terms of Section 1, the accused is deemed unfit to possess a firearm or license in future by virtue of having been convicted of a crime specified in Section 103 subsection 1 of Act 60 of 2000, and reasons may therefore be advanced or evidence presented to enable the court to consider the possibility of determining otherwise. So, Advocate Odes? No submissions.
The accused does have a firearm license. It's been recorded previously also.
Thank you. Advocate Sisa, on behalf of the state?
The accused should be declared unfit to possess a firearm.
Due to the reasons provided by court during sentence and that we are dealing with unlawful possession, due to the virtue of the nature of the offences, the court therefore makes no otherwise order and you remain to be deemed unfit, and it is followed by the following further order by court. That what Section 103, subsection 1, read with the provisions of Section 104 of Act 60 of 2000, the accused then remains to be deemed unfit, and the effect of the declaration of unfitness is as follows. All competency certificates, licenses, authorization, and permit issued in terms of this Act to any person who becomes or is declared unfit to possess a firearm in terms of Section 102 and 103 cease to be valid from the date of the conviction or the declaration, as the case may be. B, despite the noting of an appeal against the decision of a court or the registrar, the status of unfitness contemplated in paragraph A remains in effect pending the finalization of the appeal. Further, a person who becomes or is declared unfit to possess a firearm in terms of Section 102 or 102.3 of Act 60 of 2000 must within 24 hours surrender to the nearest police station all competency certificates, licenses, authorizations, and permits issued to him or her in terms of this Act, all firearms in his or her possession, and all ammunition in his or her possession. Therefore, it should be noted that subject to the provisions of subsection 9, subsection 3, subsection B, and after a period of 5 years calculated from the date of the decision leading to the status of unfitness to possess a firearm, the person who became or becomes or deemed and declared unfit to possess a firearm may apply for a new competency certificate, license, authorization, or permit in accordance with the provisions of this Act, being Act 60 of 2000, the Firearms Control Act. Okay. All right. So what we are left with is the application. Are you ready to proceed now? Okay. We just get that part of it ready.
So what we're left with is an application for leave to appeal against conviction and sentence, and an application for bail pending the outcome of the proposed appeal. Yes. If the leave is not granted, then it will be bail pending the outcome of a petition.
Just a minute, Advocate Odes. I just want to quickly grab the notepad. I haven't drafted that, so I'll have to listen to you carefully here. Just a minute. Okay. Thank you. I'm ready.
Thank you. So this is an application for leave to appeal in terms of the provisions of Section 309(1) and 309 capital B of the Criminal Procedure Act 51 of 1977, which provides that we can commence immediately by oral address, provided we list all the grounds. So it's an application for leave to appeal to the High Court of South Africa, Eastern Cape Division, held at Grahamstown, against the whole of the judgment convicting the accused of, firstly, unlawful possession of a firearm in contravention of Section 3 of the Firearms Control Act 60 of 2000, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state without holding a license, permit or authorization. The second count, Your Worship, that we seek leave to appeal against is unlawful possession of ammunition in contravention of Section 90 of the Firearms Control Act 60 of 2000, to wit a .223 Remington bullet without holding a license, permit, dealer's license, manufacturer's license, a gunsmith's license, import or export or in-transit license or other authorization to do so. The third count, Your Worship, is unlawful discharge of a firearm in a built-up area or any other place in contravention of Section 120 sub 7 of the Firearms Control Act 60 of 2000, to wit the Sisa Dukashe Stadium in Mdantsane. The fourth count, Your Worship, is unlawful failure to take reasonable precautions to avoid danger to a personal property in contravention of Section 120 sub 3 sub C of the Firearms Control Act 60 of 2000, in that the accused had control of a loaded firearm, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the 5th Economic Freedom Fighters celebration. And finally, the fifth count, Your Worship, is reckless endangerment to a person or property in contravention of Section 120 sub 3 sub B of the Firearms Control Act 60 of 2000, in that the accused unlawfully discharged or otherwise handled the firearm, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the Economic Freedom Fighters celebration, residents of Mdantsane and the employees of Gear House, with reckless disregard for the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, the residents of Mdantsane and Gear House employees. The Worship, this application for leave to appeal is based upon the following grounds of fact and law. Firstly, this is in relation to the convictions, Your Worship. In assessing the evidence, having acknowledged that the court was obliged to evaluate circumstantial evidence in this matter, the court had regarded to the often quoted dictum in Rex v. Blom and held that there are two cardinal rules of logic which cannot be ignored. And there's a quote from Your Worship. There are, firstly, that the inferences sought to be drawn must be consistent with all the proved facts, and secondly, the proved facts should be such, and Your Worship said, I quote, that they exclude every reasonable inference from them save the one sought to be drawn. Yet, we say, Your Worship, that Your Worship, the magistrate committed a material misdirection, not having any alternatively sufficient regard to all of the facts that militated against the guilt of the appellant, of the accused at this stage, Your Worship. We say that this occurred despite, Your Worship, the magistrate having held, and there's a quote here, Your Worship, the court must not take each circumstance separately and give the accused the benefit of any reasonable doubt as the inference to be drawn to each one so taken. It must carefully weigh the cumulative effect of all of them together, and it is only after it that it has been done so that the accused is entitled to the benefit of any reasonable doubt which it may have as to whether the inference of guilt is the only inference which can be reasonably drawn. To put this matter in another way, the state must then, as stated, satisfy the court that each separate fact is, let me rephrase as stated, the state must satisfy the court not that each separate fact is inconsistent with the innocence of the accused, but the evidence as a whole is beyond reasonable doubt inconsistent with such evidence. Yet we submit that Your Worship committed a material misdirection, not having any alternatively sufficient regard to all of the facts that militated against the guilt of the accused. In this regard, we say further that Your Worship further erred in holding that, and there's a quote, a number of circumstances, each individually very slight, may so tally with and confirm each other as to leave no room for doubt of the fact which they tend to establish, though each taken by itself, but as light as a feather, however, join them together, you'll find them pressing on an individual with the weight of a millstone. And we say that you further erred in this regard, Your Worship, when you held. It is further described that in cases surrounding circumstantial evidence, and circumstantial evidence alone, evidence varies infinitely in its strength in proportion to the character to the variety, to the independence one of another, and one might describe it as a network of facts cast around an accused person. That network may be that strong as it is in part, and it may also leave gaps and may then allow the accused person safe passage. It may be so close, so stringent, so coherent in its texture that no efforts on the part of the accused can break through. It may also come to nothing, and or on the other hand, it may be absolutely convincing. The law does not command that you should act upon certainties alone. We often ought to act upon just and reasonable convictions founded upon just and reasonable grounds. The law asks for no more and the law demands no less. I further refer to State v. Kwanda, 2013, 1 SSCR 137, Supreme Court of Appeal, where Maria J. stated that such an inference is only justified where the state has established facts from it can properly be inferred by a court. We say the court mentioned but only paid me a lip service to the issues raised in argument on the merits on behalf of the accused, did not have sufficient or due regard thereto. In this regard, the court mentioned the 23 statements by the investigating officer, Colonel Swartboy, the lack of DNA or fingerprints linking the accused to the firearm, no eyewitness complaint, and various other factors relating to a 9mm Glock firearm and ammunition. However, the court did not take these factors into account in its application of the two cardinal rules relating to the admission of circumstantial evidence. We go further, Your Worship. We say, additionally, the court's assessment of the circumstantial evidence and acceptance thereof did not have regard to the absence of any damage to any structure and the inability to link the suspected firearm and spent cartridge to the accused. Other significant factors in this regard were that no person reacted in fear, and the 5 VIP SAPS members had not witnessed any shooting.
I'm sorry if you can just mark there where you are busy with. She's informing me that there's a sound coming that she needs to check from our court recording machine, and I just please don't want anything to go wrong with our recording of the stage of the proceeding. So she's asking that we just adjourn for her to check and that all cables etc. are in place. I'll just leave, please. I'm not going to pack up everything, just leave it here, and then I'll be, when you're ready, they'll indicate to the police and I'll enter. Thank you. Court will adjourn. Not yet. She'll. Oh, you must go ahead. Okay, sorry. She said you'll go ahead and she'll indicate if it's now clear. Thank you.
The next point that I wish to make is that the court summarized the facts in dispute and held that it all amounts to whether the firearm that was fired on the night in question was a real gun or a toy gun. This issue is not resolved beyond reasonable doubt by the evidence led in this matter. Consequently, the accused was incorrectly convicted of the charges. Then the court further erred in allowing the viral footage to be viewed without it having been authenticated. In this regard, the court took issue with the defense having relied on the footage during cross-examination of state witnesses and the presentation of the accused's case. The court subsequently held the facts which the court will rely on without giving any real regard to the viral footage and no further findings required regarding the said footage. So what we're saying is, Your Worship said it's real evidence, it was allowed, it was referred to, and eventually Your Worship said it's not inadmissible, it hadn't been proven. Then we say the court further erred in having regard to the state witnesses en masse and holding that they were credible, reliable, and truthful. And the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witnesses to indicate otherwise. This was premised upon the court having been very impressed by Colonel Godleka, who was described as being a brilliant witness and had left no stone unturned. He had dotted every T and dotted every I. He had not made any mistake as far as the custody chain or the handling of the exhibits or serial numbers contained. The court finds him and all the above then as stated credible, reliable, and truthful. The extent to which the court had been impressed by Colonel Godleka was further evident from the finding that he meets the criteria, in fact exceeds the required criteria in his thoroughness, and he can be, or he is mentioned by this court to be not only an expert witness but a super qualified expert witness. That is the conclusion regarding Colonel Godleka. This evaluation was in turn projected by the court to the rest of the state witnesses, even though there was no factual basis to do so. This in itself indicates a material misdirection by the court in its approach to the evidence of the state witnesses and the assessment of their credibility. In contradistinction, the court held that the defense witnesses, including Mr. de Klerk, were defensive and at stages argumentative. This is further borne out by the comparative analysis by the court of the evidence of Mr. de Klerk as compared to Colonel Godleka, which was found to fall short and only be noted as mediocre. This biased approach to the testimony of the defense witnesses is further illustrated by the approach adopted towards the accused. The fact that he had stated that Mr. Mavundla should have been charged was utilized to discredit him. Additionally, he was found to have evaded many questions that had warranted a reply. The court held that it became evident that the replies were entertaining, but however the pertinent questions asked remained unanswered. He was further criticized for relying upon the viral footage whereas nobody else was. Having held that the court had to establish whether the version presented by the defense was reasonably possibly true, regard was had to the statement in cross-examination that the firearm had been in Gauteng. In this regard, the court held, and I quote, "Now as to what happened and where it was kept, no explanation is provided. It begs the question, dealing with circumstantial evidence, that what does the firearm being booked out to Mr. Mavundla in effect equate to that specific firearm is booked out to him for whenever it is needed for him or by him. Since clearly it does not mean it needs to be on his body since he left it in Gauteng. In doing so, the court appears to have lost sight of the fact that this statement had been made by the co-accused's counsel in cross-examination. There was no basis to attribute it to the accused. These findings by the court indicate the application of a type of reverse onus upon the accused to prove his defense, whereas as stated by the court, the accused's version only had to be reasonably possibly true. Put differently, the application of the two cardinal rules by this honourable court had to exclude the accused's version being reasonably possibly true. Then we say that this misapplication of the onus is further evident from the court having in its concluding remarks confirmed the two cardinal rules that require the inference sought to be drawn to be consistent with all the proof facts and to exclusion of every reasonable inference from them save the one sought to be drawn. This could never be the case in the absence of any objective corroboration that one would have expected to be present at the scene, such as damage to property, injury to people, or at the very least an expression of fear by anybody from the many people that have been in attendance at the celebration. And finally, in relation to the conviction, Your Worship, what we say is at the very least, it cannot be said that now the court might find differently or have a different assessment of all the evidence led in this trial. Consequently, it is respectfully submitted that the accused is not only a reasonable, but a good prospect of success on appeal, and this application for leave to appeal against the convictions ought to be granted. In relation to sentence, Your Worship, we submit the following. We say that the sentence imposed by this Honourable Court is startlingly inappropriate to the extent that it induces a sense of shock. We say further, due regard being had to the prevailing circumstance at the time of the commission of the offences, and more specifically that they all relate to the same event in a very limited period of time that did not exceed 1 minute, all of the counts ought to have been taken as one for the purpose of sentence. There is no need or basis to impose separate sentences in respect of each charge, as this court did. We say further, insufficient regard was had to the personal circumstances of the accused. Most significantly, he is a 45-year-old first offender who was 37 years old when these offences were committed. He has not been convicted of any other offences in the interim. Additionally, he is married. He has 3 children and a wife to support. He is in full-time employment. He is also involved in community projects and regarded as an asset to the community. There is no basis to contend that he is a danger to society, thus ought to be removed from society. In this regard, Your Worship, I wish to highlight that no regard was had to the fact that he's led a blameless life during the duration of this trial, and he hasn't committed any other offence, and this was not taken into account in the sentence that was imposed. Furthermore, when it came to his community project, Your Worship questioned the social worker who testified, Ms. Thompson, in relation to the soup kitchen under a question to clarify, and it went as follows, Your Worship, just to indicate the approach of Your Worship. It's at page 163 of the record. Your Worship says at line 16, okay, let me leave that. I have only 2 aspects left, no few in fact, because if I had it before the time, it may have been a different story. The other issue, not an issue, but if you can explain. I think we go in the circle of a radius of 5 kilometers on each side of the court building. We're going to find about 4, 5, 6 soup kitchens. So, and this soup kitchen is specifically to the area Mr. Malema is coming from. Ms. Thompson says, correct, Your Worship. The court says, so that is, what value must the court attach to that? Because I read it is from donations. Ms. Thompson says, part of, yes. And through the facilitation of the involvement of the accused, Your Worship. So Your Worship says, so it will continue. She says, it will continue most likely, yes. The court says, okay, so there's nothing special about the soup kitchen. Ms. Thompson says, there is. Then Your Worship cuts her, and Your Worship says, except that he may want to be very thankful that people are being served a meal that is outstanding. Ms. Thompson says, yes, Your Worship, and it was mentioned as part of the consideration in terms of the risk of reoffence. So the point we're making, Your Worship, is Your Worship undermined, with respect, the role that the accused makes to society. Put quite differently, Your Worship, neither, to my knowledge, does Your Worship or anybody else in this court have the right to claim that they started or initiated a soup kitchen, but Your Worship belittled that approach by saying, there's so many of them, they don't need him, whereas it was he who initiated it. So I needed to make that point. Turning to a more detailed list of what Your Worship had dealt with today, at the outset, Your Worship foresaw an application for leave to appeal. When Your Worship said, as to the firearm received from TSS, I dealt with this in my judgment, it will be an aspect for leave to appeal in the merits. There's no such finality in my judgment. This will rest until the leave to appeal. So it's quite clear, with respect, Your Worship, that you envisaged that there would be an application for leave to appeal, and that, with respect, permeated your judgment on sentence. When it comes to aggravating circumstances, Your Worship, you said that Advocate Sisa had highlighted and submitted that a custodial sentence was a normal, was the right sentence, because this was a deliberate and executed with precision. And once again, Your Worship said these merits will be dealt with when we reach that point. So what we submit, Your Worship, is it was always envisaged by Your Worship that there would be an application for leave to appeal, and that this sentence bears that out. Your Worship also dealt with the accused being in a position of trust. Now, when we refer to a position of trust, Your Worship, is ordinarily a person who's an employee, who looks after money or an assets on behalf of somebody else. It doesn't cover the situation dealt with in this matter. And we've never ever argued that there's an absence of accountability and a breach of trust. But all of this, Your Worship, will come to the final quote that I'll address Your Worship on before I make my conclusion. And that's to the effect that Madam Justice is meant to be blind and deaf, Your Worship, and not have regard to the actual specifics of the person when sentencing in the manner that Your Worship did so here. Now, Your Worship also asked the following in your sentence. You said, the event was planned, the accused said so. I stand corrected on this aspect. It was the 5th celebration, first of its kind, and I was told that it was a well-established tradition. She said, Your Worship said, I'm unsure about this. Now, Your Worship could have clarified that. The evidence was led, but to do so in your sentence, we say is a misdirection. Your Worship went further to say it was planned, the whole event was planned and ended up in the offences being committed. That can't be true. Now, with respect, we say it's a self-defeating argument, because if one says it was planned, then one must take into account that having been planned, there were no injuries, there was no damages, nothing untoward happened to anybody, and nobody expressed any fear. But that doesn't find any place in Your Worship's judgment on sentence with respect. And Your Worship then referred to the term of celebratory shots as an instance of sugarcoating, nothing more, nothing less. And we say in that regard, Your Worship erred, because it's Your Worship's finding as well. It was part of Your Worship's questioning of Ms. Thompson, that if it's my birthday, can I go down the street and start shooting? And she said, no. You said, well, aren't those celebratory shots? So the court knew all along that it was dealing with the celebratory shots, and that was the instance that had been clarified throughout. It wasn't a case of being part of another offence like a murder or anything. And if one draws a distinction here, Your Worship, and this is where we say you erred as well, in relation to the case quoted by my learned friend in this division. Firstly, that predated the one that we referred to, so it was taken into account when the second one was a non-custodial sentence by Brooks. He had already had regard to that full bench decision and didn't feel bound by it. We say those circumstances are clearly distinguishable. The man was a member of a gang. He had been involved in shooting and had previous convictions. There cannot, with respect, be any parallel drawn between that. He was in possession of an unlawful, unlicensed firearm, and somebody being handed a firearm and shooting a shot in the air, as is the conviction here. Your Worship also went into the merits of the matter. Your Worship said there should have been planning as to how, where, and what time you would take possession of the firearm, whereas there's no evidence to this effect with respect to Your Worship. The Worship also said that such actions cannot be condoned by the court and used to justify shots as celebratory shots. Your Worship, when we're dealing with sentence, we're not asking for condemnation. We're actually asking the court to blend the sentence or the punishment with mercy. So there's no aspect of condemnation that comes to the fore because the person's already been found guilty. So we say you erred in that regard as well. Your Worship also said that much was made of this matter being brought to court or not being brought to court. Now, with respect, Your Worship, the accused was asked on this. He was asked, who do you think is behind this? And he gave the version. He said, I believe AfriForum is behind this. That was his version. This has caused a lot of consternation in this court. Even Your Worship yesterday said to my member of my team, Mr. Ngayatobi, why are you bringing AfriForum into it? And all he said was, it's in their heads, I'm quoting, and then Your Worship left it. Once it had been said, it was the state that had raised it, but it was unfair to attack Mr. Ngayatobi in that regard. Your Worship also had regard to the financial aspects of this case on the taxpayers' pockets. With respect, Your Worship, that's a material misdirection. Could you imagine if we had to take everything into account in every trial, and with respect, it became something of a political speech to refer to the women who come here for maintenance can't get access to the court, the children that can't get their grants. Well, why don't we blame him for the potholes and for the weather as well, Your Worship, because they're unrelated. The NPA, if anybody, ought to have seen that the right resource available. Here we sit with no aircon. Is that the accused's fault as well, Your Worship? Because the funds that were used for this trial weren't used for that. With respect, Your Worship, it's an improper approach to take, and you misdirected in that regard. It would seem that you are appealing more to the public and justifying the decision that you're going to make rather than using a legal basis to do so with respect to Your Worship, because they're not relevant factors in relation to sentence. We cannot, on the one hand, as Your Worship did, and I've quoted you say, it's your right, your constitutional right to plead not guilty. You can have a trial. Oh, but by the way, you took up all these resources, therefore I'm holding you liable. That, with respect, is not a balanced approach, Your Worship. And Your Worship, this attitude is further borne up by Your Worship then carrying on through the time frame and saying, well, therefore the court is limited to what you're charged for and nothing more. Now, with respect to Your Worship, that implies that Your Worship wants to punish him for much more. We heard yesterday about all the different shots. We know as a fact, and Your Worship found that today there was only one shot in the charge sheet, there was one bullet in the charge sheet, there was only one ammunition, there was only one firearm. So it seems that Your Worship has misdirected Your Worship self in relation to the magnitude of what occurred that day. And it would be premised with respect then on the video that Your Worship allowed and then disallowed at the end. So we say that that's an incorrect approach to the entire trial, and more specifically the sentencing procedure, Your Worship. And then Your Worship dealt with the politics, and that it's not a political party that has been convicted here. It's a particular accused. But there's no need, Your Worship. If you say I'm holding you liable as the leader of the EFF, there's no need to say I'm convicting or I'm not convicting our party. It's self-explanatory. Then Your Worship turned to what Your Worship referred to as an uncomfortable topic, and said that Your Worship had heard all the witnesses, and Your Worship said that politics and law don't mix. They must stay in their respective lanes. Now, Your Worship, while saying that with respect, Your Worship, and in your attempt to distance yourself from that's exactly what you, with respect, made yourself guilty of. Because your reference to the public out there, to all the people that suffered on account of this, was more of a political speech than a judgment on sentence with respect, Your Worship. And this, Your Worship, was also what was displayed yesterday, as I explained, in the confrontation between Mr. Ngayatobi and yourself relating to AfriForum, when it was the state who had referred to AfriForum. And Your Worship, another aspect that was highlighted and doesn't find any meaning is, there was a debate yesterday, and even my learned friend wanted to continue further on the return of the firearm and what the correct procedure is. Your Worship, there can be no doubt, and Your Worship knows that Section 34, the court must make an order returning. The state can't decide halfway through a trial or at any juncture to return the firearm, and that ought also to have been part of Your Worship's judgment, that the rifle may be returned to its lawful owner. Your Worship identified the lawful owner in your sentence as Mr. Snyman, but Your Worship didn't go further and say, and he's now entitled to the return of his firearm because it wasn't handed by him, but it was given back to him after the event. But that wasn't taken into account. We say a more benevolent approach would have taken those aspects into account. Now, the most distinguishing feature, Your Worship, between this Ngala Nzima case of Malendana, Your Worship, was there were victims. There was a dead child of 13 years old. There was an injured child of 13 years old. Here you have none with respect. There the judge in a higher court still found the compassion to deal with the bereavement and the loss of life and the injuries, and still not impose a period of imprisonment on a person that had shot people, which is distinguishable on those facts, but it's far worse. And the simple fact remains, Your Worship, that to this day, the challenge was put out to my learned friend and to Your Worship to find any case dealing with what you call sugar-coated celebratory shots, we call celebratory shots, where anybody had been charged for it. And Your Worship says that's not a relevant factor. We say it is with respect. If one can have regard to how many soup kitchens are in the neighborhood, one can have regard to how many times this actually happens in real life. And Your Worship, having berated the accused for taking so much of the court's facilities and time, then turned around at the end of the sentence. Each case is unique. Everybody's equal before the law, and everybody has a right to a fair trial, so we're all equal. So, Joseph, how do we find somebody more accountable on the basis that is the leader of a party, but yet we say we're all equal before the law? And your worship said the specific accountability of public officers way much more. It doesn't mean you are not treated equally, and I don't understand that concept. Specifically, your worship, when we have regard to the decision that we quoted in our heads of argument in the Constitutional Court, and ironically dealing with the EFF versus the Speaker of National Assembly, where they stated as follows, in reference to the case that did away with the death penalty, your worship, and they say, and I quote at paragraph 235, "It is after all the embodiment of the legendary Lady Justice, a dispenser of justice who's blind and deaf, to images of any reports on the good reputation and notoriety of personalities before her, but never misses any legitimate and relevant legal or factual points for or against any litigant." So what we're saying, your worship, is that justice must be dispensed without fear, favour or prejudice. It's known, it's accepted by your worship. That includes Lady Justice being blind and deaf, your worship, and not overemphasising the position that a person plays in society when it comes to sentencing them for conduct, which conduct, as we've stated, your worship, was over within minutes with respect. May I just have a look here? Worship also went further to say that the accused had been dishonest in his approach to the court, and with respect, your worship, there was no basis for that factual finding, particularly in relation to sentence, and this, your worship, then impacted on your worship's then finding that your worship could have regard to corruption cases and fraud cases dealing with dishonesty. And that goes back, your worship, to the issue that I raised earlier of being in a position of trust. It seems that reasoning permeated your worship's logical reasoning throughout this matter, and we said that that is a major irreversible misdirection on your worship's part. So in conclusion, your worship, what we say is that taking account of the crimes of which the accused was convicted, the interests of society and the personal circumstances of the accused, as well as the unique facts pertaining to this matter, the custodial sentence ought not to have been imposed. The imposition of a custodial sentence is startlingly inappropriate to the extent, your worship, that it induces a sense of shock.
Whatever is, I can't hear you when whatever is playing.
May I just listen to my colleague?
No, not at the back. There's a is it the police? Please, can you just a minute?
Your worship,
I couldn't hear what that last sentence.
I'm instructed by Mr. Ngayatobi to point out, and it's a valid point, if one has regard to the fact that there's never been a case of this nature, that we're all in agreement on that. So this is a novel situation that we seem to be dealing with judicially. So there's no sentence, there's no precedent that one can say, oh, well, the other case is exactly the same. This is what they did for celebratory shots. If you look at Oscar Pistorius, if you look at all the other cases, there were people in a built-up room. He was given a non-custodial sentence for discharging. He wasn't charged with the possession, but it's very similar facts. This could even be regarded as a duplication. Possession, and there are cases that say possession of the firearm, possession of the ammunition is impossible without, I beg your pardon, discharge of a firearm with ammunition is impossible absent the firearm and the ammunition. Why should they be treated separately? And that's the case with Oscar Pistorius. It's common cause factor. He received his friend's firearm. He shot that firearm. He wasn't licensed to possess it. He was thinking of buying one like that. That was the justification. Yet he was only charged with discharging the firearm. Here we have the very, very similar situation. Not only, your worship, did the state separate the charges, your worship then found him guilty of all three and gave different sanctions, different punishments on each and every one of those three charges, one being a 5-year sentence, your worship, with respect. So if we have regards to those and we do a comparative, it cannot, with respect, be said that this appeal is doomed to predictable failure. It has a very, very strong prospect of success, as we say. So we respectfully request leave to appeal against conviction and sentence, Your Worship.
Thank you, Advocate Odes. Advocate Caesar, I'm not sure if you already, based on what you've heard, I
Copy of them. I just want to check if Mr. Odes has got a copy of whatever arguments.
Yes, I've got a working document. If you want my working document, it's not a final. I didn't do Your Worship, so I had just the application.
I realized that's why.
So it's my working notes.
Yes, no,
I don't ask for
fine.
his notes.
No, I fully agree. I understand. I would think that's why I'm saying, has he listened, and then does he need a few minutes to prepare a reply? Because I've memorized. I don't require. I've listened. I don't need your working document. You need a few minutes, Advocate Caesar?
No, Your Worship, but we can proceed.
Thank you.
If my understanding is correct, Your Worship, this application deals with Section 309 of the Criminal Procedure Act, where leave to appeal is applied from the Magistrates Court to a High Court. Insofar as the leave to appeal application is in respect of conviction and in the respect of the sentence. One of the factors that has been mentioned, if my memory serves me correct, and counsel can point out to me whether it is inaccurate, that Your Worship failed to take into consideration that the principles in Rex versus Blom relating to the only inferences relating to the incident in question, that the accused did in fact possess the firearm and that he did in fact fire those shots. Yes, please, our submission in that regard, the court took into consideration all the evidence, including the video evidence, which the court deemed to be admissible. And like I've already said previously, that it was enough evidence for the court to come to that particular shots, and that there are no prospects of success relating to the conviction and sentence in this regard. If we deal with applications for leave to appeal, I've heard counsel say there are good prospects, but that's not the only requirement. The mere possibility that another court might come to a different conclusion is not enough to convince the trial court to grant leave to appeal. The reason for that, why the courts have taken such a view, if Your Worship is of the view that the conviction was correct, allowing an application for leave to appeal will absolutely amount to a waste of judicial resources when there's no prospects of success. I submit that counsel might have an arguable case, but there's no realistic chance insofar as the conviction is concerned that he will succeed. It has been pointed out in so many cases, the Supreme Court of Appeal has stated what is the test of reasonable prospects of success, postulates it's a dispassionate decision based on the facts and the law, that the Court of Appeal could reasonably arrive at a conclusion different to that of the trial court. In order to succeed, therefore, the appellant must convince the court on proper grounds that he has prospects of success on appeal, and that those prospects are not remote but have a realistic chance of succeeding, most required to establish than that of a mere possibility of success. A mere possibility of success, an arguable case, like I said, or one that is not hopeless is not enough. This is basically what I said counsel have argued before, Your Worship. There must be a sound, rational basis to conclude that there's a reasonable prospects of success. Insofar as the sentence is concerned, before I go there, I just want to say the court have thoroughly considered all the evidence. Like the court pointed out earlier, the court had a long judgment dealing exactly with every issue that has now been raised by counsel, whereas the court have made those findings in respect of each of the points raised. It's my submission, insofar as the conviction is concerned, there is no reasonable prospects of success and no realistic chance that it will be overturned on appeal. Insofar as the sentence is concerned, Your Worship is of the view that I did request that the 15-year sentence must be imposed. I also provided alternative sentences which might be imposed to the accused. I'm satisfied with the sentence that was imposed by this court. As a matter of fact, I find it to be fair, and regarding to the facts of this case, there's also no prospects of success relating to this particular sentence, that a different court will come to a different conclusion, and that the court should dismiss this application. The issue with bail, I will deal with Your Worship as we go along, depending on the court's finding whether there are indeed prospects of success or not. Thank you.
Thank you.
Your Worship, let me start with the arguments made about the correct test. It seems that my learned friend wishes us to argue that Your Worship is wrong, but we don't have to argue that you are wrong. It is on appeal that we will argue that you are wrong. What we are dealing with today is merely a question of whether there is a realistic probability that another court might come to a different conclusion. In other words, is there a realistic prospect that that will be the case, both on the questions of fact and on the questions of law. So it's crucial to underscore that test. And the exercise is also not a repetition of the case that Your Ladyship has had. Your Ladyship is now functus officio in relation to your judgment. So we don't have to persuade Your Ladyship that you were wrong. We simply have to show that someone else looking at the same facts might come realistically to a different conclusion. The only argument made by the state, and it's important to examine their case, what they have said now, is around R versus Blow. That's the only thing they have said. Now, Your Ladyship, if you contrast that with the case that has been made on behalf of the accused, R versus Blom is one aspect, but there are so many other grounds for leave to appeal that have been advanced. The reality, Your Worship, is that none of those have been responded to. What you have is just a generic submission that there is no reasonable prospect of success, and there is no reasonable likelihood that a different court looking at the different facts might arrive at a different conclusion. So in effect, you are then not dealing with an application on conviction that has been seriously contested by the state. They've raised only one ground and they've ignored each and every ground, and they've put them under this omnibus category that there is no reasonable prospect. So that's point number one, that actually this is not meaningfully opposed by the state. Point number two is that what that does is that it therefore leaves those grounds uncontested. Now, that has serious implications then for your Worship's weighing an assessment. So if you have an accused person that gives you 10 grounds, and you've got the NPA that responds to one ground, and that leaves 9 grounds unopposed in effect, what does that then do to the court is the court now supposed to fill the gap left by the state? I'll tell you why they've taken that approach. It's because they themselves accept that this is a strong application for leave to appeal on fact and on law. So if that is the case, then that the only logical deduction to be drawn from the unserious opposition is that actually this is a cogent application for leave to appeal. Then it leaves your leadership's role very easy, because you don't have to decide whether you are right or whether you were wrong. Someone else must decide that. The job is very easy. The High Court must make a fresh evaluation of the evidence and make a determination whether the convictions were safe or not. That then takes me to the question of sentence. We have a similar approach taken by the state. This is what they said. I noted it down. They say, we've asked for 15 years, we've got 5 years in one and 2 years in the other. We are very happy with that. Of course they are. But the question is whether there is a realistic chance that someone else looking at these facts might arrive at a different conclusion, or whether or not there is a reasonable likelihood of success on the appeal against sentence. If I have to weigh, and I'm not doing that weighing now, the two appeals, the conviction and the sentence appeals, I would say the sentence appeal enjoys the most excellent prospects of success. One, because you are not dealing with a field that is occupied by judicial precedent. And it is correct as a matter of law, if you are not dealing with a field that is occupied by consistent precedent, to say the higher court must relook at it. And that is not because your worship is admitting that you were wrong. Your worship is simply saying there are different views in this field of law, and let the higher court relook at this and make a determination. Just take one example on the discharge alone. Look at the 4 cases we looked at yesterday, if you remember all of them, Your Worship. You know, none of them resulted in direct incarceration, none, 0. And you look at the case presented by the state, they are unable to point to a single case of a discharge that results in direct imprisonment, or discharge alone. Then you look at your leadership's finding, count 2, which is the discharge count. You've sent Mr. Malema to 2 years direct imprisonment. Now, can you be confident that there is no other court that realistically may come to a different conclusion? I think that if you took that view, your leadership will probably fall into an error. Even if you look at count 1, the possession charge, it is correct what my learned friend said, that these cases differ. Yesterday, I took your lordship to 7 different authorities. I picked 3 where there have been fines of as low as 2,000 rands in circumstances where there have been injuries. So even that, an imposition of 5 years is not a safe direct incarceration, no option of a fine, no suspension. It's not necessarily a safe imposition. So it would be proper for your leadership to say, look, I've done my job. Now let the High Court relook at this matter and decide what it wishes to do. I'm not going to complain about the declaration that Mr. Malema is not fit to possess a firearm, because it follows from the convictions. If those convictions stand, then there's no problem with that. But if those convictions, there's a realistic chance of setting them aside, then as a matter of logic, the balance follows. So what am I saying then on sentence? I'm saying to your leadership that it is possible that someone else, realistically possible, that someone else will say this sentence induces a sense of shock. Now we can say that, my lady, without fighting with your leadership about who introduced politics in court. We can say that purely on judicial precedent. And we can say that purely on application of legal principles. And when your leadership considers this, your leadership, we accept, will be dispassionate. And your leadership will be blind to the politicians sitting behind me, and will be looking at the accused without identity. and then decide, well, does he deserve to have his case re-evaluated by a higher court or not? Now, if your ladyship even refused that, then we will say that your ladyship is not acting in accordance with the oath of office. But we trust your ladyship that you will act in accordance with the judicial oath of office and send the matter to the High Court, let them re-evaluate it. They might agree with your ladyship, but there have been many instances before that you think you are right. I've been there myself. I think I'm right, and then five judges sitting in the Supreme Court of Appeal say, sorry, acting judge, you were wrong. And that's where we are today. Your ladyship may be overturned. And so we ask, therefore, with respect, this is a discretionary matter, but at the same time, it is a matter of application of settled legal rules. So we would therefore ask that you send the conviction, you send the sentence to the High Court, as you please. No, Melinda, I actually never spoke politics. I just responded to a political speech.
Yeah. Okay. I think we can return before one. Since I've heard what you've said, Advocate Odes, and thereafter Advocate Mkaitobi and Advocate Sisa. It's not a difficult issue as you've stated. The law is clear. I'm going to extract the relevant parts and return, can we say 12:30? That will give me sufficient time. Please, just a minute. Okay, thank you. Court will adjourn.
Inappropriate, according to him, stating that consideration could have been given to the prevailing circumstances on the day of the commission of that crime, which speaks to perhaps her framing of the crime as a celebratory shots. Advocate Hodes saying she erred in just labeling the conduct as celebratory shots, which she then said was a form of sugarcoating. Again, there, Hodes saying it's not sugarcoating, it's just a fact. Those were shots fired in a jovial environment, not in a murder or attempted murder scene. Then Hodes also going on to state that there was no need for the sentences to be separated, at least the sentencing with the 5 charges to be separate. That was among their pleadings. They had wanted for him to get one sentence and not each charge coming with its own sentence. Then the defense also made a point to the magistrate's statement earlier on the firearm matter, where she stated that upon appeal, she would deal with the matters, which was suggesting that she envisaged a custodial sentence, almost suggesting a foregone conclusion, at least from what we're hearing from Advocate Hodes, that she saw a foregone conclusion even when they were still seized with the pre-sentencing proceedings. Now, still in that vein of a foregone conclusion, he touched on the magistrate scolding Advocate Mkaitobi for mentioning AfriForum, which he says was unfair to touch on, basically touching on her character in that moment or temperament in presiding over this matter. He then went on to address her on her statement around the financial aspects of the case. He says that that was a material misdirection on her part to mention that there were women who couldn't come for maintenance issues, kids who couldn't get grants when Malema's trial was in session. He says that should have been the role of the NPA. They should have prepared for an appearance of a public figure such as Malema, but that she was making those statements perhaps to appeal to society ahead of what he says was the sentence she intended to hand down. Now, on her statements on politics having nothing to do with the case, where she went on to say that for her, it was not convicting a political party but an individual. Hode says that was grossly unnecessary. It goes without saying that it is an individual and not a party that had been convicted. He then goes on to some of the case law which they relied upon in pre-sentencing of the discharging of firearms cases, specifically speaking on the Nzima case, where a child actually died as a result of the discharging of the firearm, but there was no custodial sentence. Hode is saying that that should have swayed her somewhat, but it seems it didn't. He even says he challenges her to find a similar case where an individual was charged, saying there was none that she could find. And then when it was the turn of Advocate Mugai Toby, he started off by saying that the prosecution is misdirecting itself on the leave to appeal proceedings that we're all now witnessing or watching, believing that the defense now has a role to prove that the magistrate was wrong, whereas their role at this point is just to advance that another court presented with the same set of facts could possibly arrive at a different conclusion. He then says that he actually believes that the sentence on appeal enjoys prospects of success, excellent prospects of success at that, because he says there's no judicial precedence on the matter. So most certainly they are confident and still hoping that they will be granted that leave to appeal. Of course, at 12:30, we'll get exactly what becomes the ruling on this matter from Magistrate Toinette Olivier. We're now joined by Ulrich Roux, a legal expert, just to get his sentiments on everything that we've been witnessing. A very good afternoon to you, Ulrich. It's 2 minutes to 12, so I suppose a very good afternoon. It's been a very eventful day, from starting with the sentence itself, 5 years imprisonment for count 1, 2 years for count 2, 20,000 fine for count 3, or 6 months imprisonment. What is just your take on the sentence that we just heard?
Yes.
A very good afternoon, Ulrich. I don't know if you can hear me.
100%.
Ulrich, a very good afternoon. I don't know if you can hear me. Let's try again. All right, it seems as though Ulrich is reading himself there. We'll try and re-establish the line to Ulrich. But some very important points made there by Advocate Mugai Toby, specifically on the proceedings that we are watching right now, which is the application for leave to appeal. Because for some, I suppose, or at least he felt it important to shed light on what this process was about, that at this point, they are in no way looking to prove wrong, at least the sentencing by Magistrate Toinette Olivier, but at this point, they just want to convince her that perhaps another honourable court would arrive at a different conclusion when presented with the same set of facts. And again, it's important to talk about what really becomes the process in an appeal. In an appeal process in the country of South Africa, most certainly you don't re-argue the facts. Or what would happen is that not new facts would be brought before, but really the interpretation of the law becomes what is at play here. So interesting that they still do believe, though, in as much as the defense, the prosecution, is saying that they believe the case is watertight, nobody else would arrive at a different conclusion. They do believe, as the defense, that indeed they might arrive at a different conclusion, at least for Thembeka Mugai Toby, on the very aspect of the sentencing. He says it enjoys excellent prospects. We are still attempting to try and get a legal expert to just give us their sentiments just following that sentence of 5 years behind bars for Julius Malema. A bit earlier on, when our colleagues were speaking to some EFF members, it seems they had prepared for such an eventuality for them where there would be a custodial sentence. As you can see there, some of the live visuals spread across the country. We also have EFF members in Mpumalanga that have gathered, that have been monitoring those proceedings. We'll be taking you to our various reporters where they're covering those visuals for us, or the scenes there of EFF members. As you can see, it seems some of them are still united in song, but as has become the norm with political parties, even when in strife or experiencing a level of strife, they are happy, they will unite in song. Whether it's a moment of sadness, they again will unite in song. So not something out of the ordinary, that still, in a moment such as this one, they would all still be united in song, I suppose, in an effort to comfort themselves or bring their spirits up as they do await to be addressed by their leaders as soon as those proceedings are done. But what is still to come from our understanding, that beyond the leave to appeal application, which speaks to the conviction and the sentencing, there will be bail proceedings. So most certainly a long day for the EFF leader and his legal team today. and as was also stated a bit earlier on, that there is legal counsel in Grahamstown, or that this legal counsel, part of them, will be travelling to Grahamstown. As you can see, the live visuals of them huddled up, speaking to EFF leader Julius Malema just as soon as, or at least before they recommence again at 12:30. It was our understanding that a certain legal team, be it maybe part of this legal team, will then travel to Grahamstown to the High Court, where then again the matters will continue pertaining to the appeal, and time is of the essence because many would understand that an appeal suspends or stays the execution of an order. In this respect, the sentencing. So everything becomes a time game in the legal space when it comes to the role of an appeal. You want to be granted that appeal at least so that you can be able to stay the execution of that order, which now would be ordering him to go to prison. So most certainly a very long day for this team, a very long day even for EFF members. Julius Malema having stated to journalists that on the day that journalists leave the city of KuGompo, he would also be leaving with them. And I suppose that now becomes the effort of his team to ensure that he does get granted that leave to appeal, and they file an application for leave, and then which would allow him to stay that execution of the order, and then he returns home after this. Let's take you now to outside the court precinct, where again, my colleague Sakina Kamwendo is standing by to bring us the very latest. A very good afternoon to you, Sakina. It's been a long day, even for you guys outside the court precinct. All right, I'm getting from my producers that my colleague Sakina Kamwendo is not yet ready for us. Let's try and bring in a legal analyst. I believe it's Ulrich Rue. Let's try. All right, let's take you. I understand that Sakina, now it is live television. Sakina Kamwendo is now ready for us. A very good afternoon, Sakina. It's over to you.
Well, good afternoon once again, Fundo, and of course, welcome back. And we now have heard the sentencing handed down by Magistrate Twanet Ulafir, and getting some reaction, of course, from the family members who are coming out. We saw Julius Malema's son Ratanang exit earlier, and I'm joined now by Mr. Pratik Madavu, who's the spokesperson for the Lemba Cultural Association. Mr. Madavu, your reaction to what has happened inside court?
Shalom, and thank you, Sakina, for having us again. Well, we went to the court knowing that we've got a guilty verdict. What we wanted was a different punishment in sort. Whilst we got a different one, we are resolute. We have produced a very strong young man in Julius Malema. We have produced a man who knew what he was going to encounter when he goes inside today. So what we have learned and what we have observed while we're inside the court is that it's a consultative sort of a judgment where a judge would leave sort of consulting, come back and not able to read what she has decided on. But we are not in that particular corner. We are saying that legally we have the right to appeal, and that is what we are doing now. We are presenting our case for an appeal so that a different court can find a different verdict than the one that we have set here. The state doesn't have a strong case in this case, but we know that at some point you would want to think that there are some forces behind. Whilst we don't want to dwell much on that, we are saying that we will go the legal route. Our son knows very well that we might come across this whole thing, but we were ready to do an appeal. That is why we are still in court. We'll go back in the next 30 minutes to submit our appeal presentations so that the legal course must take its course in a fair and fair way.
Have you had an opportunity to speak to Julius after the sentencing was handed down, Mr. Madam?
We discussed before, and that we are going to get either or. And if we get this, this is what we're going to do. And if we get this, this is what we're going to do. So in this case, we knew that if we're not getting a suspended sentence, an incarceration sentence, then we will do the next process of appeal, of which that is what we are doing. So in that case, we knew what we were expecting. and what we will do in terms of a different conclusion on the case.
Mr. Madabu, thanks so much for your time, and of course, thank you for speaking to us this morning. And we will catch up with you again later in terms of the family as you leave from here to the next process.
Shalom.
Thank you. And that, of course, the family reacting to that sentence, Samkele, for Julius Malema. Patrick Madabu is the spokesperson for the Lemba Cultural Association. And what we can see behind us now is, of course, the entrance to that court. We are seeing some of the members who were on the inside, but of course also coming out.
That's Julius Malema's best friend. The bold individual, forearm. That is Julius Malema's best friend. On the right, to Ratanang. He's wearing black.
Wait, I can't see Ratanang. Oh, I see him now. I see him now.
Always, that way you want Julius Malema. He is always after a particular individual. Forearm, they call him for he's Julius Malema's best friend. In Julius Malema's most darkest of moments, him, Lesiba Gwangwa, Ali Bushielo, the entire gang that used to be called the Limpopo Cartel.
During the on-point days.
During the on-point engineers days, those are the individuals around Silo Malema. They are back. Once again, they are together. Fori is always alongside Julius Malema. Hence, you see him going back inside the magistrate's court.
All right, we're going to send it now to Stima Mfeku, who is in Makanda, I believe. So let's, or is he inside? But either way, we have this whole thing covered, and we're crossing to various centers. But I do believe Sidima is inside, and he's ready, waiting for us. Sidima?
Well, Sakina, I can tell you right now, even here in Makanda, where we're anticipating that if that application for leave to appeal this matter is not granted in that KuGompo City Magistrates Court, then that particular matter is going to be coming here in Makanda. The Deputy President of the party, Godrich Gadi, is here, as well as the TG of the Economic Freedom Fighters, Mpile Mautwe, with some of the supporters of the Economic Freedom Fighters. And I anticipate, that everyone is disappointed in terms of that decision that had come out, DP, that Julius Malema is sentenced to 5 years direct imprisonment. What's the party's reaction to that?
Our spirits are very high. That's why we are here at Grahamstown. And there is another team at the Constitutional Court. He will not sleep for a minute in the cell. We will get a judge on duty to hear the matter for a bail appeal.
Yeah. Most of what the reasons leading to the judgment by the magistrate have not been accepted by the defense. We've heard both Advocate Hodes as well as Nkaitobi saying that the magistrate was not presenting the actual facts in the matter. Speak to us about your reactions to what has happened in court leading up to this day, and also the sentence that was handed down.
We rather appreciate that the defense has made its case in court. The matter is still sub judice. At 12:30, the magistrate is coming back, and we may not have to preempt her. Whatever she has said about the conviction and the sentencing and her remarks are still a matter of engagement, and we will challenge them accordingly. We are here in Grahamstown with Zilwa attorneys. We are ready to trigger Plan B, and we are also ready in the Constitutional Court in Braamfontein to trigger Plan C.
Just take us through the plans B and C. What are these plans?
Urgent application for a bail appeal pending the petitioning of the judge, President of the High Court.
This probably means that we might, you as the party might be in KuGompo City and Makanda, in fact in the Eastern Cape, for quite a while. These matters may be argued the next day, which is Friday, maybe leading up to the weekend as well. Have you prepared enough for the people, especially those who are gathering in various areas, especially in KuGompo City?
The matter will be heard today in the afternoon, latest in the midnight. It won't go beyond that. We can assure you we have all contingency plan put in place for all our people and supporters who are everywhere in South Africa, in Limpopo, in Mpumalanga, in the Western Cape, in Northern Cape, in KwaZulu-Natal, everywhere. We had planned for this day properly.
Yeah. All right, thank you very much for your time, Deputy President. We're going to definitely be out here for every step of the way that the EFF is going to be taking in making sure that they keep Julius Malema outside of prison. We understand that the Economic Freedom Fighters president has been sentenced to 5 years direct imprisonment on count 1, and also count 2. He was also, sentenced to 2-year jail term, and other, counts he was fined. We're going to be monitoring what is going to be happening here in Makhanda. We understand that the party is waiting for the court in KuGompo City Magistrates Court to finalize, and then Plan B and C are standing by. But now we're going to go to Mahikeng, where our reporter is standing by.
Indeed, we are here at Mahikeng, the northwest capital, where we are seeing EFF members are gathering here. They are just outside the Mahikeng or Mabati Convention Center, as earlier on they were at Mahikeng, at the High Court here in Mahikeng, in the Northwest Province. So the leadership of the province has already delivered the message to the EFF members here in the province with regard to the latest developments. The leader, the Julius Malema, being sentenced to 5 years in prison, emanating from those 2018, or emanating from that 2018 incident where he was fired, or he fired a rifle in the air at EFF 5th anniversary rally in the Eastern Cape. But I'm now joined by the ANC or EFF, Deputy Provincial Secretary here in the Northwest Province, Justice Dabampi, just to talk to us about what is going to happen throughout the day as they are waiting for the outcome, as the lawyers of the EFF leader Julius Malema are trying to appeal this sentence. Thank you very much for joining us on SABC News this afternoon, Justice. Just maybe talk to us about your reaction as the provincial leadership with regards to the sentence.
No, thank you very much, and greetings to the viewers at home. Well, as the EFF, of course, we are disappointed in the sanction that has been given out by the racist magistrate of East London. However, we are not shocked. You remember that we had already anticipated that she'll try to send our president and commander-in-chief to direct imprisonment. So we are not shocked, but we are disappointed that she indeed took the mandate of AfriForum, she took the mandate of Donald Trump, she took the mandate of Solidarity and all the white racists. That this shows her true color. However, we have not yet lost hope in the judiciary. That is why we came even prepared. You'd know that we are currently in the Eastern Cape High Court. We are also going to the Appeals Court to make sure that the president does not spend even a single minute in prison. So we are very confident that the judiciary will indeed ensure that the president does not spend the night in jail.
Were you hoping for a different outcome, though? And what was the outcome that you were hoping for?
We're hoping for at least a suspended. However, because of she gave out what Donald Trump last year said must happen to the president, that is why we're taking it on appeal. We're appealing both the verdict, not only the sanction, also appealing the verdict, the guilty verdict, because we know the president is not guilty. We know the president did not fire any firearm that they allege to. This case is purely racist and politically motivated. So, as I said, we are not shocked. We are just disappointed that she adhered to the mandate of Donald Trump.
Yeah, but why would you say it's Donald Trump's mandate? Because he was charged before Donald Trump returned to the White House for the second time.
You remember that last year Donald Trump asked a question to the president of the country that why is Julius Malema not in prison? And we believe because of that mandate, then the magistrate took it upon herself to ensure that the president goes to jail. But you would remember that even AfriForum is the racist organization that has been looking for a president high and low, and now they are using the racist magistrate to ensure that they win their political battle that they failed to win all these years. They failed to win, and even now they have not won.
Thank you so much. I'm sorry, Justice, to cut you there. That's the EFF Deputy Provincial Secretary in the Northwest Province, Justice Dabampi, saying that they were hoping for a different outcome, a suspended sentence, at least also saying that they are hopeful that their CIC will not even spend a night in a prison cell. With that, it's back to you in studio.
All right, Tabitha Moss there in Mahikeng, France. Thank you very much for that reportage. We bring it back to studio now. We're joined by legal expert Ulrich Roux to get a sense or analysis from him not just on the sentence, but also the proceedings we've also been monitoring now, which is the oral submissions by the defense in regards to the leave of appeal application. A very good afternoon to you, Ulrich. Just share with us your sentiments. We heard from Advocate Hodes at the start of his oral submission saying this sentence is starkly shocking. Your take?
Yes, well, certainly if we look at what the state was arguing for, they requested that the magistrate hand down a sentence of 15 years imprisonment, whereas the defense requested a suspended sentence coupled with a fine. So I think that the magistrate struck a fine balance between the two different arguments. Certainly a period of imprisonment of 5 years for conviction on these offences is a very clear message being sent out by the court that any firearm-related offences will no longer be tolerated by our courts and certainly should act as a deterring factor for any would-be offenders going forward. When a magistrate or presiding officer does hand down a sentence, she's required to consider the accused person's personal circumstances, the severity of the offence, and then the message that is sent out to society. And I think that she considered those three factors with great care, and that a balanced sentence was handed down. Once again, certainly a clear message being sent out to society and to would-be offenders that firearm-related offences will no longer be tolerated by our courts.
Mm-hmm. And then what of the submissions by Tembeka Toby, where he went on to say that according to him, the sentence at least enjoys excellent prospects on appeal, that there is no judicial precedence when it comes to a matter such as this one. We even heard from Advocate Hodes saying he challenges the magistrate to actually go and look for cases similar to this one.
Well, one could expect them to make those submissions, given that they are now applying for leave to appeal. Our law is clear that the magistrate now needs to decide whether her sentencing and her conviction should be granted leave to appeal, and that judgment she will be handing down shortly. But our rule adopted by our courts is that if there is a reasonable prospect that a higher court will come to a different conclusion, then Julius Malema should be granted leave to appeal. So one would have to wait and see now whether his legal team has convinced the magistrate that she should grant leave to appeal. If she refuses leave to appeal, then he will, of course, be within his rights to immediately approach the High Court in the Eastern Cape to lodge an urgent application for leave to appeal. And one can then expect that he would also launch an application for his release on bail, pending the outcome of that leave to appeal. So certainly a number of legal steps that still lie ahead in this matter, and certainly with the sentence being handed down today, one can expect numerous applications to come in future. The first of that being judgment that's going to be handed down shortly on whether he is granted leave to appeal or not.
Were he to be granted leave to appeal, talk us through the proceedings. What is permissible in such a process? New evidence, we know, cannot be brought in an appeal process, so meaning you're not arguing new facts, but really an interpretation of the law. But I'm sure you're well versed to actually take us through what exactly that means. If they were to appeal, what would it look like? What is the ambit under which they then operate?
Well, they would most certainly argue that the magistrate made a material misdirection when considering the evidence that was placed before her. And as you correctly point out, they would only be allowed to argue their appeal on what transpired during the trial court. So that entire record will now be typed up, and they will have to draft their appeal based on what was said and the evidence that was led during the trial. Now, Julius Malema's version was that the firearm that he handled was only a toy gun. It was not a real firearm, and that no live ammunition was indeed fired. I don't think that his version was a good one. I don't think that it is going to hold up in an appeal court. The state led strong evidence by a ballistics expert confirming that it was clear that it was indeed live ammunition that was fired from that firearm. And that version was accepted by the magistrate, and Julius Malema's version was rejected. We also heard his legal representatives now confirming that his prospects of success on appeal are good because the state did not adduce any DNA evidence confirming that he in fact handled the firearm. Now, this is contradictory when you compare it to his version during the trial, where he said yes, he did handle the firearm, but it was a toy gun. So certainly a lot of facts which the legal team for Julius Malema will need to consider when they proceed to that appeal process. And as you correctly point out, an appeal is lodged only on paper and then argued in open court, and there are no emotions as there are in the trial court. You cannot base a decision based on the demeanor of a witness or how that witness withstood cross-examination. It is all on paper. So certainly the legal team, in my opinion, have their work cut out for them should they proceed to the appeal, on their appeal to the High Court.
All right, Ulrich, thank you very much for your analysis. That is legal expert Ulrich Roux speaking to us, saying, at least from where he's standing, the legal team or the defense of Julius Malema have their work cut out for them. We continue to just give you a sense of the country today as EFF supporters monitor proceedings from the sentencing. We take you now to our reporter Griselda Lewis, who is here in Gauteng. A very good afternoon to you, Griselda. You've been there straight after that sentence, the 5-year imprisonment sentence. What has been the sentiment of those gathered there? What is the ambit under which they then operate?
Well, they would most certainly argue that the magistrate made a material misdirection when considering the evidence that was placed before her. And as you correctly point out, they would only be allowed to...
All right, unfortunately, my colleague Griselda Lewis is not yet ready for us, but the conversation does continue here in studio. I'm joined by politics editor Mzwandile Mbeja, just to give us a sense, because we heard... Good afternoon, firstly, Mzwandile.
Good afternoon.
We heard from Magistrate Twanette Olivier that politics and the law do not meet in court, but most certainly we do know that the outcome thereof, in this respect, would have political implications. When looking at this year, it's 2026, it's an election year. Local government elections are around the corner. You've got a leader now, having heard from at least our legal analyst, Ulrich Roux, a leader who will be bogged down with this legal process, which most certainly does not end anytime soon. Yeah. What could be the implications of all of this?
Well, obviously, depending on what is going to happen now at 12:30, and then beyond that, if things don't go their way, of course, the High Court in Makhanda will obviously be approached. But politically, this is a political leader. Remember, as a politician, as a leader of a party, so your very existence is to get state power, is to wrestle state power. So if you then are then hindered from doing that, that now talks to, I think, your career path, so to speak, is somehow disturbed. Because if indeed this stands, so he will have to resign as a member of parliament, because you can't be a member of parliament convicted. So it's a huge blow if it indeed continues like this. And I think that's the reason why he has decided that he will challenge it right to Braamfontein Constitutional Court, because if indeed it is confirmed by the courts, so it means he's out of politics for a period of time, and then time waits for no man, and then what's happening in that space. So clearly, it's in his interest that this gets overturned in one way or the other, so that his political career can continue.
All right. I'm just going to leave it there for now. We're going to come back and revisit this specific conversation, because in most political parties, one would think that the leader's absence should not somehow cripple the functioning of a political party, which speaks to the dynamics and how the EFF has been led for the longest time. But we'll talk extensively on that. I want to take us back now to Griselda to just get sentiment on the ground from EFF supporters. A very good afternoon to you, Griselda. What has been some of the sentiment of those gathered there as they heard Judge Twanette Olivier hand down a 5-year sentence for Julius Malema in prison, among others?
Well, Mfundo, just like in many other provinces, there are thousands of EFF members and supporters that have come out to different locations to listen to that sentencing. And I can certainly tell you that from those that are gathered here, there's a great sense of disappointment in terms of what the outcome of this ruling has been. Of course, many have been sitting and watching as that application for leave to appeal has been brought forward. Of course, you would know that Julius Malema's lawyers indicating that the presiding magistrate was unjust in the sentence that she gave, also indicating that another court would be able to find otherwise. In other aspects as well, the state basically wanting this application for leave to appeal to be denied, stating their case as well. As you can see here behind me, I'll ask my colleague Lereko just to show you the number of EFF members and supporters that are here. It's a huge sense of disappointment from them in terms of the outcome of this particular matter at the moment. And in actual fact, I think many of them are saying they're disappointed with what the outcome has been at the court, KuGompo. That's, of course, in the Eastern Cape. And in actual fact, in a few moments, we will be speaking to some of the senior leadership of the EFF that is here. In the Johannesburg CBD, of course, we have been showing you as SABC News in various parts around the country where there have been EFF members who have gone out in their numbers. They've been waiting in anticipation for today's sentencing. But of course, they're saying it's not over. And as you can see, of course, the lawyers representing Mr. Julius Malema are going a step forward. In fact, we knew this a couple of months ago that if this did indeed not go his way, there were already talking about an appeal which was going to be brought forward at that particular point. I'm not sure if I'm going to be successful at this particular point, and I'm going to try and see if at all I can bring in some of the senior leadership of the EFF. Nkululeko Dunga, I know that at this particular point, most of the speakers, of course, are KuGompo, but obviously this is a very disappointing result out of KuGompo for the EFF, for its leader, Julius Malema.
Well, look, it's expected. The commander-in-chief always knew that leading a revolution, it's either they are going to kill him or they are going to arrest him. And but one thing is certain and for sure is that economic freedom in our lifetime will be realized. So we're at least anticipating this because this is a line of march from Donald Trump who made it very clear that the commander-in-chief must be arrested. So this is a follow-up. Now, we can't leave our comrade president into the hands of the current correctional services which are under Peter Groenewald, a racist of note who's going to be in charge of the lives of the commander-in-chief. So in essence, there is a process that's unfolding. We are appealing and asking for the right to appeal at any single level that might arise. But having looked at the conduct of the magistrate, one can just draw conclusion to the fact that she might just not grant it, but we are ready. And we must also note as a society that the right to appeal at this level is a direct respect of the structures that are there, particularly in terms of the judiciary, and an appreciation that the EFF is fully respecting that element of it, and it's well within our rights to do exactly that.
And I mean, it's not only going this far, Mr. Dunga. We're also talking about the possibility of even going as far as the Constitutional Court. In fact, that is what the leadership of the AFF has spoken about, to exhaust all options to ensure. We've heard what Advocate Tembeka Ngcukaitobi, SC, said. He felt that the sentencing was unjust and that another court would be able to find otherwise.
Well, the exhaustion of the process is as a result of the unfairness of this particular matter. We brought in, obviously, our case, we brought in our views, as well as mitigating factors in reference at least to the sentencing, which was disregarded completely by the court. And, one can even come to a determination that had they accepted at least what we brought upon them, would have most likely accepted even what we deem unfair at that level. So we're well within the rights and the process of escalating it and taking it to any other high court including the Constitutional Court. It's well within the rights and the processes that are there, and it should not be seen as an abuse of the judiciary.
And what happens if, the EFF fails in this regard? There's just so much that is at stake, in particular for the leader of the EFF.
Look around, that's the EFF. And the Commander-in-Chief understands that he is leading a battalion of revolutionaries that can exist well beyond the lives of everyone who is here. It's not an individual organization, but I can tell you for free that tomorrow the Commander-in-Chief will be at Women Under the House.
Thank you very much, Nkululeko Tunga of the EFF there, talking to us as thousands of the supporters as well as members of the EFF have gathered here in the Johannesburg CBD. They're saying they're not giving up hope. Of course, this application for leave to appeal continues. The EFF, its supporters as well as its members, still very hopeful at this particular stage that perhaps another court would find otherwise. And this is, of course, the wish of Julius Malema's lawyers as they're arguing for this leave to appeal. We've heard from the EFF leadership as well as the legal teams that they're going to be taking it as far as they can to the highest court in the land. This is the constitutional court of the country. That would be the highest arbiter, of course. But what is quite clear is that this matter is far from over, and these members of the EFF as well as supporters are watching quite closely what the next steps will be and what the next outcomes of this particular matter.
All right, my colleague there, Criselda Lewis, but let's take you back to the city of KuGompo. Magistrate Twanette Olifiel now on her seat. Let's listen in.
Okay, I'll proceed now. Just a few, so I just need to solve a few minutes. Take 1 second. All right. You may be seated, and the court will proceed with the leave to appeal application brought by the defense with regards to conviction as well as sentence in this matter. Firstly then, for record purposes, the court needs to be particular. The matter is before court in terms of section 309 capital B of Act 51 of 1977. Therefore, leave to appeal in respect of conviction and sentence. The said judgment was handed down was it 1 October 2025, and sentence imposed today, 16 April 2026. The defense, being Advocate Hodes SC and Advocate Nkukai SC, had immediately after sentence indicated their intention to seek leave to appeal conviction and sentence. I will deal with two case laws that specifically is used daily by our courts dealing with matters of this nature. And I will refer to State v. Mabena and another, 2007, 1 SACR 483, Supreme Court of Appeal decision. The following was noted. It is the right of every litigant against whom an appealable order has been made to seek leave to appeal against the said order. Such an application should not be approached as if it is an impertinent challenge to the presiding officer concerned to justify his or her decision. A court from whom leave to appeal is sought is called upon merely to reflect dispassionately upon its finding after hearing arguments and decide whether there is a reasonable prospect that a higher court may disagree. In this regard, the only comment the court will make is with regards to one aspect as highlighted by Advocate Hodes, and that is that the court had anticipated the appeal. On that, I would say it is the duty of every trial court who imposes an appealable or hands down an appealable judgment or sentence to at all times be aware you handed down an appealable sentence. So it should be the norm to anticipate an appeal, not the exception. Further then, the court will highlight that in State v. Mackenzie 2003, 2 SACR 619, Supreme Court of Appeal, the decision stated that where the appeal, it's not relevant because the defense was not vague in the grounds that they raised. It didn't merely state a general error on the side of the court or the presiding officer. It made specific points. And the requirement according to that case is that the appellant must do so and state the grounds clearly and specifically, and that has been done. As to what then constitutes reasonable prospects of success, Plaskett AJ in State v. Smith 2012, 1 SACR 576, Supreme Court of Appeal decision, describes it concisively as follows. What the test of reasonable prospects of success postulates is a dispassionate decision based on the facts and the law. That a court of appeal could reasonably arrive at a conclusion different to that of the trial court. In order to succeed, therefore, the appellant must convince the court on proper grounds that he has prospects of success on appeal and that those prospects are not remote but have a realistic chance of succeeding. More is required to be established that there is a mere possibility of success. There must be a sound, reasonable basis for the conclusion that there are prospects of success on appeal. It is also noted by this court, and I want to place it clearly on record, that in a criminal case, a magistrate or the trial court should not take the easy way out and leave everything to state counsel or the appeal court when it is the correctness or otherwise of her or his decision that is at stake. When confronted with appeal, the trial magistrate is duty-bound to make an honest reassessment of his or her decision in light of the appeal. It is helpful to everyone concerned to know whether or not the trial magistrate still abides by his or her decision despite the appeal. If for some reason the trial magistrate has had a change of heart, it is more honorable to say so than to adhere to an indefensible decision. In doing so, it may save precious time and costs to all parties concerned, and the ends of justice cannot be served by prevaricating and being non-committal when the liberty of a citizen is at stake. Therefore, the test is straightforward, namely, whether there are reasonable prospects of success in the envisaged appeal against the conviction, rather than whether or not the appeal ought to succeed. That is, let me stop there. That is the general principle applied by courts with regards to an appeal. I'm going to do it in the following fashion so that it's not repetitive, and state as follows. I'm going to deal with conviction and sentence in one ruling. Therefore, a court will have to be careful in its judgment in a leave to appeal application not to influence the outcome of an appeal, and for this reason is curtailed in dealing with the merits to the limited extent necessary to explain its reasoning for granting or not granting leave to appeal. So for this reason, the court will refrain from any further comments as to ensure that there is no interference with any proceedings that may follow. With regards to the clear direction from case law, this court is to state clearly that whether it stands by its decision to convict the applicant for the reasons already mentioned during the judgment, and to state so clearly, in this regard, Mr. Malema, the following ruling is made with regards to the application. With regards to the decision with regards to conviction, this court abides by its decision as stated on record. This court has not had a change of heart and clearly stands firm on its decision to convict. Therefore, leave to appeal in respect of conviction is not granted. I've not finished, please. However, with regards to sentence, after listening carefully to the address placed on record, in respect of sentence, there is always a possibility that another court may come to a different conclusion regarding sentence. Therefore, this court does not have any intention to stand in the way of such a possibility. Safe to say, no, I'm not going to add that. The court will not stand in the way, and therefore leave to appeal sentence in this matter is granted.
There's one outstanding matter, and that's the issue of the release of the accused. And the accused has been on bail since the 27th of November 2019. So it's 7.5 years ago. He was on warning, I beg your pardon. The accused was on warning. He's abided by every request to be at court, every order of the court. Based on the Hudson, Anderson, and the Nadu decisions, we'd ask for reinstatement of his release on warning, Your Worship. I understand it's not opposed by my learned friend, but I'll allow him to confirm that. Thank you, Worship.
Sorry, there was just, are you saying you are applying that he be continued to remain on warning?
Yes, Your Worship, please.
Thank you, Advocate Otis. Advocate Sisa?
Yes, I thought we had an agreement that the accused can be released on bail. I hear differently now, but I also have no objection if he is released on warning on this regard. Thank you. We had an agreement.
Okay. I'm not wanting to be difficult. I also, in principle, do not have any objection to the request. Normally when we go to the aspect of bail pending appeal, there are normal conditions that is applicable which the applicant will have to comply with. So I'm also in charted territory now when the status remains on warning as to how we'll deal with the conditions.
I think the normal practice will be remains on warning until the appeal is prosecuted. If he fails to prosecute it, or if he gets an adverse finding, he must hand himself over within 48 hours.
Within 7 days, it will remain the same.
As you should. Thank you.
Okay.
7 days.
7 days, yes. Just for my own, sorry, Advocate, for my own, because as you are well aware, any court who grants appeal or whichever petition will follow, I'm not sure, needs to keep a register with the progress. So is there a date which we may agree on, which there can be an email or an update as to the progress? Merely to know it's filed, and that is the end of my involvement.
The appeal against sentence will proceed, but will still be petitioning as we're entitled to, for leave to appeal against the conviction, which is within, I believe it's 15 days, which is 3 weeks. Because it's normal.
I think on my side I will have to prepare, or we will have to prepare quite a lot of documents for you for that procedure. It's why I'm asking more or less, because it's a time-consuming exercise, so that I can, we'll start getting it ready in any event, I think.
My friend is correcting me, it was 21 days. I know it's 3 weeks, it's 15 court days, so it's correct.
Okay.
So if we could set a date within 3 weeks of now, Your Worship, because then the Worship can have proof that the petition will have been served and filed by then, which will be an indication of everything taking place.
No.
As Worship, thank you, Worship.
Thank you. Then, as you've heard, Mr. Malema, the court has no intention of changing the status of yourself, and therefore you remain on warning pending the outcome of appeal and petition regarding conviction. Thank you.
As the court pleases, Your Worship, I think that concludes our round.
Thank you. Bye-bye. We'll take a final bow. Final bow.
Will be leaving the court precinct in a short while. What is the sentiment of those gathered outside after hearing that at least he has been granted leave to appeal on the sentence?
That's right, Mfundo, welcome back. So as you just saw in shot there, those motorbikes that were stationed here, ready to escort the security vehicles behind us, if indeed the appeal conviction did not go the way and Malema was not granted bail, to whisk the legal team of Advocate Lawrence Hodes as well as Tembeka Ngugaitobi SC to a helipad here in KuGompo and whisk them over to Makhanda where they were ready with that appeal. But of course, you saw the motorbikes being released there, Samkele, because they no longer needed.
Indeed, they're no longer needed. Our sources were saying that they came out earlier on during the recess to tell them change of plans. There's no need to take the legal team to a helipad to go out to Makhanda. It does seem as if he will be granted bail. He will be able to go home.
It has been confirmed.
It has been confirmed within the next 7 days. Then he will go and appeal the sentencing that has been given, effective of 5 years into imprisonment. It's no longer urgent. They no longer need to go to Makhanda. As you saw him earlier on, he is alongside his friends, his family, his siblings, and also his comrades who are fighters who are supporting him throughout this particular ordeal. We've seen they've got a number of events in a number of high courts across the country. So Nkululeko Tunga leading the members of the fighters and supporters of the EFF in Gauteng. So effectively, he is going to go home. He is on the current bail conditions, but the conviction of being guilty on the firearm discharge, he's not been given an opportunity to go and appeal that particular judgment, but he can appeal the sentencing of 5 years on count 1, 2 years on count 2, running concurrently on all the other 3 counts, on the 20,000 rands fine, or a 6 months incarceration for each.
And I think that's important, that distinction, because it is, of course, he's not being granted appeal on the conviction, can't appeal the conviction. The magistrate here, Toinette Olafir, believes that another court will not come to a different determination in that regard. But as far as the sentencing is concerned, she is quite convinced that there is a possibility, the prospect does exist, that another court could come to a different determination, whether worse or better. That is something that remains to be seen. But of course, all the urgency stripped of what was set up here in KuGompo, in Makhanda, and in Johannesburg, as far as the legal process is concerned.
It's better. It will mean no jail term at all. But if there is a jail term of any possibility, it will definitely go to the highest court in the land because it has huge political ramifications for him. So we are in for the long haul within this particular case, which will evidently reach the Constitutional Court should the higher court find that the jail term sticks or the jail term is reduced or is given a higher jail term. He will petition the SCA. He will ultimately go to the Constitutional Court.
And that is the important part, the political ramification at this point, because as things stand with that conviction, of course, the appeal puts things in abeyance as far as the sentencing is concerned. But of course, if as things stand, let's put the abeyance aside, the law and the Constitution are very clear that if you are given a custodial sentence, a jail sentence without the option of a fine for 12 months or more, then of course you can't serve as a member of parliament.
That is where, Sakina, it becomes tricky, and which is where I say it will ultimately go to the higher courts. It will go to the High Court in Makhanda. It will ultimately, whichever court he chooses to appeal this particular judgment, it will go to the Supreme Court of Appeals. It will go to the Constitutional Court because of the political ramifications it has. This is a war, if one may liken it like that. He has won the battle in the immediate, but the war is not yet over. He still has a number of hurdles to get over in order to get the sentence reduced to a fine or to a non-custodial sentence. That is where he needs to now channel his attention. The conviction is done and dusted. That there is no prospect of appeal, as said by Toinette Olivier, the magistrate in this matter. It is now the sentence. Reduce the sentence to less than 12 months with the possibility of a fine in order to keep your parliamentary seat.
And of course, we're out here in front of the Magistrates Court. We can see as we turn our attention there to the entrance. So what we've seen is, of course, the positioning of the vehicles. And we are expecting, of course, the legal team to exit. They will come out because their work here is done for the day, effectively. Julius Malema and, of course, his family and the leadership of the EFF, as they did yesterday, are expected to make their way to the stage where he will address those who are, of course, gathered here.
He is expected to come out. They are coming out now. There are members whom I see coming out. It is the leader of the EFF. They are with the leadership of the party. They are singing. You can see them chanting songs. They are going up to effectively go to the podium. You can see the likes of Carl Niehaus as well being with the members of the Economic Freedom Fighters as they go up to the podium where the stage that has been shared. You can see now Sinawo Tambo, who is the spokesperson of the Economic Freedom Fighters, who is leading the members of the party in song and chant. You can also see the vehicles of Mr. Julius Malema that are also lining up to go to the back of this particular truck that has been set up, where they will ultimately address the members and supporters of the Economic Freedom Fighters, Sakina.
Indeed, Samkele, as those who are in court make their way out and just trying to see who's getting into which vehicles here, hoping that we can, of course, also just get a view of the legal team while everybody's focusing on those going to the stage. We're keeping an eye on what's happening on the back alley here to see if we can perhaps get word, if possible, from Lawrence Holders or Tembega Ngogaitobi.
We definitely will try that. We just have to also move in order to get our camera to the podium in order to be able to take the speech of the leader of the Economic Freedom Fighters as he is out on bail. They will have about 7 days to go and appeal this particular sentence.
We know they are already standing by. They are ready to already make that said appeal. So they are waiting in Makhanda, and that is where Stima Mfeku is, of course, along with the legal team waiting there. That includes, of course, the deputy president of the Economic Freedom Fighters. But of course, as we say, please bear with us and these pictures as we are going to try and navigate our way as well towards the stage where Julius Malema is expected to address the crowd here. But in the meantime, let's keep with the sound and let's move on.
That are also lining up to go to the back of this particular truck that has been set up, where they will ultimately address the members and supporters of the economic freedom fighters, Sakina.
Indeed, Samkele, as those who are in court make their way out, and just trying to see who's getting into which vehicles here, hoping that we can, of course, also just get a view of the legal team while everybody's focusing on those
visuals there, a sea of red, if you will, a number of supporters there waiting to be addressed by EFF leader Julius Malema. My colleagues in transit now to try and get us the exact perfect visuals of EFF leader on the stage now, as has become the norm, to address those supporters gathered there. And I suppose the most important becomes to almost give them a message of support, that even as they are there as supporters of their own leader, but the leader needs to somehow give a message that he is in high spirits, he's okay, and that allows them to also be in high spirits, remembering that this is an important, very crucial year of local government elections. So any moment we'll take you to those visuals where EFF leader Julius Malema will be flanked by his leadership, addressing the members there following that ruling by Magistrate Toinette Olivier that grants them leave to appeal the sentence. And very important what we heard from Tembeka Toby, that he did believe that that sentence on appeal enjoyed excellent prospects of success because there was no judicial precedence. And also the magistrate going on to state that for her in such a matter, it is important that a magistrate, when granting or considering an application such as leave to appeal, must be a magistrate that acts dispassionately, removes herself from her judgment. As Tembeka stated, she is functus officio. That's a legal term to say that her role in this specific case has come to an end, so most certainly not married to a judgment, and granting them that leave to appeal at least the sentence. But that's where we leave it for today. What an eventful day it's been on the agenda. Thank you very much for joining us. My colleague Mpositole is standing by to bring you more of this rolling coverage of the EFF leader Julius Malema's firearm sentencing proceedings that have come to an end. Any moment she'll be taking you to, of course.
Kesaskate sekama branches ngalale bosoko babengeko. Kesaskate sekama branches. Branches ngalale bosoko babengeko. It's a Mandla Our 2 comrades there by the gazebos, all of us, let's come forward. Let's come forward, comrades. Into esizeleyo apha nguCommander in Chief nguluzayo. Let's leave everything else you are doing there at the back and focus here. The Commander in Chief and President is coming to address us. Masondeleni sonke fighters. DJ, President fika ngene ndini elizwi apha. Help us out. Awe 2 ochocho akanacala la izombopha kanjani wabulela we siyabulela we esetochocho akanacala hey yo nizombopha kanjani siyabulela we siyabulela we izandla setochocho akanacala iyo nizombopha kanjani siyabulela we izandla uchocho akanacala nizombopha kanjani siyabulela we Antiniva, sabulela we. Esetochocho akanacala. Hey yo nizombopha kanjani wabulela we. Sabulela we. Esetochocho akanacala. Iyo nizombopha kanjani sabulela we. Tena siyabulela we esetochocho akanacala iyo nizombopha kanjani siyabulela we nanguchuchu esetochocho akanacala iyo nizombopha kanjani siyabulela we Tina siyabule nangujuju izandla esetochocho akanacala iyo nizombopha kanjani siyabulela izandla siyabulela we esetochocho akanacala iyo nizombopha kanjani siyabulela we Sabulela we esetochocho akanacala iyo nizombopha kanjani sabulela chuchu
amandla Viva EFF, viva! Viva EFF, viva! Long live the spirit of Mama Winnie Mandela, long live! Long live the spirit of Mama Winnie Mandela, long live! Long live the Commander-in-Chief, long live! Long live the Commander-in-Chief, long live! Futek AfriForum, Futek! Futek AfriForum, Futek! Down with DA, down! Down with DA, down! Amandla! Ngawethu! Thank you very much, fighters. As we all know that today we are all happy. And before we start our program, we have a pastor amongst us that we are going to invite to lead us with a prayer. Thank you.
Let's all just pray. Our Heavenly Father, we thank you for this day. We have been praying for the court proceedings. We want to thank you so much for the progress so far. And we want to thank you for protecting each and everyone from different provinces. Even right now, we pray that, Lord, as the proceedings are still continuing, be the God who will show us the way direction and give us wisdom. In the mighty name of Jesus, we thank you so much, Lord. In Jesus' name, amen.
Thank you. Amandla. Thank you very much, fighters. Let me first greet our president, Julius Malema.
Amanda, before I bring the president, want to bring the leader of Washabi to come and bring the president a poem.
Aya malimba ke tsebe bokhalaka. Oya khatangwe ya penama. Ene wa chetsi ba chabana bangonga. Banya chitulula chifanjerere. Ba chilamba kufa. Ene mushabi asasebe mbutulu kwembe ono shaba ngombe. Ndiyene muzungu nukufasena. Shalom alaikum.
Amanda, asijakhile ndawo ngithi. Nazo ke sanikeza abashaka.
Amandla. Viva EFF, viva. Program Director, I'm here today representing the labor community or the family. We are so very happy today in this final day, which it was so very hard in our hearts. You know, we know that we as the labor people, we used to go across difficult times, but that time is still on, but we are the resilient people. And we know that at this moment, we are not surprised when we see the CIC came across these difficulties. But we as the Lemba, we are here because it's our child. There's no one who his child is trapped can just stand aloof and look. So we are here, we are so very happy, but though we wanted to observe the law or the law of the country as well, that is still consistency. We know that when we look this from our own perspective, we see that it has got many influence from different institutions or from different political parties. So we know that as a leader of a political party, there is a bearing for him to be put in jail. So as we are from the Lemba community, as a resilient people, we know that the journey is still continuing and will win at the end of this road. Viva!
Shalom, my fighter, shalom. Shalom, my fighter, shalom. Shalom, my fighter, shalom. Irini kisikaga bakamata. Marale anziba kamu. Yase anzibi abuji salva alim belle juju. Yalo banamaye so akina jenga dia bauje dinchi. Dia baurengeli dia belle juju rumogai. Albona juju. Ate adi jona lemboje kidomu dia katruba. Amanda, viva EFF, viva! Viva EFF, viva! Long live the Commander-in-Chief, long live! Long live the Commander-in-Chief, long live! Long live the Commander-in-Chief, long live! Amanda! I saw me fight, I saw me! 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 Amanda! Thank you very much, fighters. Suela ngo 2018. Silana mhlanje. I'm going to not even waste time to bring the Commander-in-Chief. Gobalenda outside Sisa Dukashe Stadium to say, President, we are here today and we are still moving forward. Come and talk to us, President and Commander-in-Chief. Usinikeze umkhomandlela. Amandla!
Amandla!
Viva EFF, viva! Tata EFF, tata! Tata EFF, tata! Down AfriForum, down! Down AfriForum, down! Down racism, down! Down racism, down! Thank you very much, Secretary General, our leaders, the National Chair, DSG, TG, and Deputy President, our parents who are here, our pastors, traditional leaders, the leadership of the Youth Command, our family members who are here. We support the fact that today was not an easy day, but at the end of the day, the fighters emerged victorious because the ground forces have always stood firm behind the logo of the EFF. We want to salute you, the ground forces, for always being there from since 2018 until to date. They thought you were going to be tired, only to find that you have an appointment with the future and you are not going to be discouraged by a white magistrate who kept us here for so many years. She kept us here for so many years and comes back and blame us for disturbing the courts. We did not come to court on our own. She invited us to the court and we responded. You know, if you don't come to court, you get arrested. If you come to court, they say you are disturbing court. Therefore, you must go to prison for disturbing court. So we don't know what to do anymore. But that was not the law. That was racism speaking. Magistrate Olivier is a racist of note. And she must know that in her sleep, that she's a racist and she's possibly a member of AfriForum. That's why when you mention AfriForum, she cannot hide her emotions. Yesterday, when SC Mugai Toby mentioned AfriForum, she jumped. But it was not Mugai Toby who was mentioning AfriForum. It was the state which wrote in its heads of argument about AfriForum. When he was responding what the state wrote, she said, don't bring AfriForum. And Mugai Toby said, I'm not bringing AfriForum. The state wrote AfriForum in their documents, and I'm responding to what they said. She said, let me read. By the way, she got those heads of arguments 2 months ago. She was not aware that by saying she wants to read inside court, she was confirming that she did not read the heads of arguments. She just entered court without knowing what is contained in the heads, in the arguments that the lawyers were putting before the courts. So we are tried by a magistrate who doesn't read, who read when you appear in front of her. Otherwise, when you are not there, she doesn't read the heads of arguments. If you read heads of arguments and someone says AfriForum, you'll automatically know that I saw AfriForum somewhere in these documents. And you can't ask the question, where is that AfriForum? What are you talking about? We're trialed by a magistrate who doesn't read, who uses emotions, who speaks politics, who says we are stopping people who are coming to collect maintenance. We are stopping grannies who want to come to court. But in reality, this court was never closed. The public continued to use this court. So she doesn't have any reason, none whatsoever. She goes around fundraising reasons why we must go to prison. They took a firearm which they say I used. She was not aware when it was mentioned in court that the firearm has been handed over back to the owner. She appeared shocked, but the witness who was testifying for me wrote about the firearm being taken away. She was not aware. You know why? She doesn't read. She doesn't know what is contained in the documents that are before her. So we are dealing with someone who doesn't apply the law. The law, whether you hate someone or not, you have to answer the question, what does the law say on this matter? She will not answer that question because she can't read heads of arguments, 21 pages. And those 21 pages are quoting the judgments which were written before about matters that are similar to this one. How can she read all of those judgments if she can't read 21 pages? So it's clear that even the law that we are referring to, she can't refer to it because her and reading are not friends. They are not the same WhatsApp group. She's the most incompetent magistrate who read a judgment for 3 days. It is never done. She does so because we suspect she doesn't write her own judgments. They ask a simple thing, leave to appeal. It's a simple matter. The state stand up and they do not say anything. You still ask for 30 minutes to grant a leave to appeal or not. You are not asking for 30 minutes. You are still going to ask your masters, do I grant the leave to appeal or not? So you are dealing with an invisible hand that is controlling the proceedings in that particular court. So we must make sure that she gets reported to the Magistracy Council Commission because the prosecutor knew about the judgment before she could read the judgment. A day before, she told accused number 2, you must go and fetch your gun tomorrow. And the accused number 2 said, you can only fetch a gun if you are not found guilty. How did the prosecutor know that accused number 2 is not going to be found guilty to an extent that he tells him to go and fetch a firearm? That's the first misconduct the prosecutor committed. The second one, which the Eastern Cape, East London sub-region must go and open a case of perjury. He lies in court yesterday. To lie to court is a criminal offense. He says, we gave the gun to accused number 2 after he was acquitted. When you said not guilty, that's when we gave accused number 2 the gun. But he forgets that when you collect a weapon or item that was used as evidence, when you collect it back, you must sign for it. There must be a date, there must be a time. So if it's 10 o'clock, they will write 10 o'clock, they will write a date. You look at the time of collection and then look at the time of judgment that he collected before the judgment was passed. That is the second misconduct of a prosecutor. But a prosecutor has got no duty to hand over the item which was used in court without a judgment of a judge. He gave himself a power he doesn't have. He took the evidence before the court and handed it over to accused number 2 without a judge saying, you can now return this item back to the owner, or you must give it to the state to destroy it. So he thought he's got the power he doesn't have. The only thing we need to do is to make sure that this prosecutor, who is arrogant and suffers from a short man syndrome, is taught a lesson. And we can only teach him a lesson by sitting on his neck and making sure that he is prosecuted and is arrested for lying to court and is disciplined at work for exercising the powers he doesn't have. And this magistrate must be reported to the commission. Why? How did the prosecutor know about the judgment? Because you are the only one who knows the judgment. Only you, the magistrate, could have told the prosecutor about the judgment. And to tell the prosecutor about the judgment outside the representatives of the accused, it's wrong. It's not allowed in law. If there is anything you want to communicate to the prosecutor, you must call the defense to come and you communicate in front of a defense. So clearly, you've got a special relationship with the prosecutor as a magistrate, and that is a misconduct on its own. So we must make sure that we pursue her for being ill-disciplined and abusing her power as a magistrate. So we are going to appeal this matter. We are going to make sure we go to Grahamstown and we are going to dismiss a judgment which was poorly read and which was poorly written. She has granted us leave for appeal on sentencing and refused to give us leave to appeal on conviction. We must petition the High Court to appeal the guilt verdict and the sentencing itself. Today, because all they wanted was to have me sleep here for one night, but they didn't know the reason why the Deputy President is not here. He is at Grahamstown. Because when you apply for leave to appeal and they refuse it, you have to apply for bail. She has a right to refuse it. Then you must petition the High Court to apply for bail at the High Court. So we've got the Deputy President in Grahamstown with papers ready, so that when she says you are not getting bail, you are going to sleep here, the Deputy President immediately files the papers at the High Court and make an agent application. We are not small children. We prepare for any eventuality. If she goes this way, we go the other way. If she goes this way, we go the other way. Because we know that we are dealing with an invisible hand, and therefore you have to be prepared at all material times. The judge at Grahamstown was ready and waiting to listen to our case at 3 o'clock, because we had already told the clerk of the court that we are coming. Not only that, we had a chopper waiting at the airport for the legal team to fly immediately to Grahamstown. We are fighting the devil, and we must fight with everything. 2 minutes they must see you here, 2 minutes they must see you on the other side. That is the power of the EFF. We prepare from all the fronts because we are fighting the enemy, and the enemy is white supremacists. We can tell you now, no sober judge will ever agree that a person shoot one bullet and then is sentenced for 5 years. It is because she has not read her own judgment to know that a reasonable, normal, presiding officer will never come to that determination. So, comrades, we are done with her. That's why when she said to me, you can leave now on a free bail, I looked at her and I said, bye-bye. Because I've seen her ugly face for too long. So I'm going, I will no longer appear before that ugly white face. I'm going to the highest court where they don't use emotions. They use the law. What does the law say? And apply the law. So we must not even look back. We're going forward. The campaigns of the EFF must continue business as usual. I told you when she found me guilty that I'm going to appeal until the highest court, until the Constitutional Court. So those who thought they will have me in jail, you must know I'm still around. I'm not going anywhere. I told you yesterday that tomorrow I'm going home with you. And that's what is happening. Wherever the enemy is, it's highly pained by the fact that we are going home. We did not even have to pay for a bail. They just said, free bail, go home. So we are going home to work for the EFF. That's what home means. It means the work of the EFF continues. We are going to do our door-to-door. We are going to register those who are not registered. We are going to make sure that we win municipalities when the elections come. They are trying by all means to silence this voice. They will never win. Once more, they failed today, they will fail tomorrow, and they will fail in the near future. The sooner they accept defeat, the better. They will never win against us. They tried us when we're still young, and they will never win with us when we're this old. We've got an experience of a 65-year-old at a 45-year-old. So these members gave me a title called Ishe. That title is only given to people who are 65 years old and above. But I was given that title before I even turned 45. They said, when they were arguing with the president of the Lemba Cultural Association, that you can't give a child a title reserved for the elders, the president of the Lemba Cultural Association said to them, tell me one thing that he has done, that you have done, which he has not done. We are giving you this title because you are 65. Tell us, is there anything that you did in your life which Julius did not do in his life? They couldn't answer that. But he turned around and said, if we were to ask Julius, have you ever done something that this old man of 65 years he hasn't done? The question is going to be yes. Because he has lived beyond those years you are talking about. When they've written him off and carried coffins and declared him dead, still he emerged and continued with life. When they put a concrete on his grave and thought this plant will never rise because we have put a concrete on this plant. He emerged through concrete, and he's still standing till today. That's what they don't want to see. When they expelled us from the ANC, Baleka Mbete saw us in parliament. And then she was shocked because she was confusing parliament with ANC meeting. She was like, what are they doing here? Because we expelled them. That's when we had to remind her, well, we are not here because you invited us. We are here because our people brought us here, whether you like it or not. So they've been trying to close doors everywhere. Taken my houses, I bought double, triple what they took. Taken everything from me, I've got triple what they took from me. So I don't know why they're not getting tired. And they thought, no, let's leave him, he's going to die. He's overweight, I've lost weight. So I don't have a problem of gout or anything of that sort. They are trying all manner of things. And still I rise. Because they never gave birth to me. And no man or a woman who didn't give birth to me can determine my destination. My destination is in the hands of my ancestors. You fight with me, my ancestors will emerge. They have never failed me. That's why even today, when everybody thought it is done, my ancestors showed up and said, this one of ours, we are going back home with him. And we want to make sure that he returns home safe. So if you've gotten access to them, just tell them, please leave him alone, because he's still going to emerge. When you finish him this side, he comes from the other side. I mean, you were demoralized and thought the EFF was dead when the sellouts were leaving the EFF. 2, 3, 4 people left. 700,000 joined the EFF after 3, 4 people left. They thought that those people formed the EFF. And those people say they formed the EFF because it was formed by you. Why didn't the EFF live with you if you formed it? Why is the EFF still alive after you left if you formed it? They did not form the EFF. The EFF was formed by the blood of the workers of Marikana. The EFF was formed by petrol attendants, by the domestic workers, by security guards, by the unemployed youth of South Africa, by the students of South Africa who wanted to be registered, and only the EFF could register them. The EFF was formed by the poorest masses of our people. It doesn't belong to us. It belongs to the future generation of African children, because this is the only weapon they have to fight racism, to fight poverty, to fight unemployment, to fight inequality. So no one, no individual must ever claim they formed the EFF. You want to know who formed the EFF? Just go and look at that mountain in Marikana. You will have a sense of where does the EFF come from. The EFF does not come from a village called Mahonisi. It comes from Marikana. That's where we owe our existence to the people of Marikana. We owe our existence to the widows of Marikana. We owe our existence to the children of those who were killed in Marikana. And for as long as the workers are still receiving lower wages and they are still fighting for their rights, the EFF will still exist, whether I like it or not. The EFF is spoiled of choice. You must go and look at the parliamentarians of the EFF. They are the youngest. The rest of other political parties are led by Abu Gogo Nabumkul. Only the EFF has got Naledi Chirwa in parliament. The rest of them have got Sisa Dukashe. So, once you've got the young on your side, you are guaranteed of the future. We are not a veterans league. We are an organization of young people, very energetic young people, and the future looks bright because we've got Lonzi, who is in parliament fighting for the rights of the people of South Africa. We've got all of you here. Even if you kill Malema, another Malema is already born. That Malema will emerge and take the EFF forward. So we want to say to the police, you are here in your numbers, in your uniform, and you took an oath not to take illegal instruction. But you are here on illegal instruction because you're not supposed to be here. You're supposed to be in the office of Oscar Mabuyan because he stole masters at Fort Hare. That's where you're supposed to be. You're supposed to be on the streets fighting criminals who are raping women out there. But you are here. There was another one inside court, many of them wearing masks. I was like, why are you wearing masks? Are you that ugly you don't want us to see your face? They must stop sending police to destabilize the proceedings of the court and blame the EFF. They must blame themselves and the police. Why do you bring a special force of police inside court? Majority in that court is old people. The young people are outside. You bring policemen, highly trained, to go and guard this old man who's walking with a stick. Or this, what can this old man do to that old judge? The only thing he can do is to take this stick and point at that judge. So tall and so taller one day. But you bring a special task force in court when there is a problem of extortion in Umtata, when there is a problem of gangsterism in Quebec. You bring police and want to complain about state resources instead of using the resources of the state effectively to fight crime in the Eastern Cape where our people are being murdered. Some commanders do not apply their mind. We were in an ad hoc committee. You remember the EFF shutdown. Police spent 80 million to stop an EFF shutdown. EFF shutdown was a constitutional, peaceful protest. How do you spend 80 million as if you are preparing for war? War against your own people. War against the people who voted for the same government. They are protesting, saying, stop load shedding. You spend 80 million on police to go and stop the protest of the EFF. Instead of taking that 80 million and go and fix Medupi so that our people can get electricity, they are complaining about electricity. We are led by fools. That's why they don't know how to plan. We are led by fools. That's why they steal masters at Fort Hare. So all of those fools must be removed from power. And we can only remove them from power if we go and register young people who are not registered, including yourselves here as ground forces of the EFF, when you go back home, you must take out your phone. Anyone who wants to enter your taxi, you say, give me your ID number. And then you check them on your phone, whether they are registered to vote or not. If they are not registered to vote, you don't chase them away. You register them immediately. If they refuse, you must show them taxi rank. Or this is not taxi rank. Taxi rank is that side. This taxi, this bus is for people who are registered to vote for the EFF. If you are not registered, you must never enter the EFF transport. If you are not registered, you must never receive the T-shirt of the EFF. When a person says, give me a T-shirt, or before I give you a T-shirt, come here, ID number. Let me check if you are registered. If a boy proposes you, I think or there is no problem, we'll go to the tenders. Let's pass the first stage first. Bring your ID. You must tell them, or I don't date people who are not registered. You are a danger to society. I don't date people who are a danger to society. If you are a parent, you must say at home, before I dish up, bring your IDs. I want to check if you are registered. Because in my house, I will not harbor danger to society. So everyone in your family, your boyfriend, your girlfriend, your schoolmate, your teacher, anyone who wants to touch your beer, you must pull it back. Hooray, wait. Fag ID number up. Fag ID number. Fag ID number. When we eat meat here in Eastern Cape, because you like meat too much, and every man goes to the meat with his own knife. Now we no longer demand your knife. It's your knife and ID number before utacha inyama. Ungaisiki inyama before ufaki ID number. Once you are not registered, uzoisika inyama. But let's register you first. Inyama ikhona igcwele, but we want to register you first. If he says no, or go sit on the other side. This is the side of registered people. These gogos who vote ANC here in Eastern Cape, you must make a plan for them. Yeah, a lot of gogos, ANC still wins with a lot of numbers in Eastern Cape. Eastern Cape votes for ANC. The following day, they are carrying a coffin, crossing a river to the other side. Only you can stop that. You vote the ANC. The following day, your children cross a river to go to school. They are putting the books on top of their head because their parents have voted for criminals which have eaten money which was supposed to build a bridge in that particular village. So you must stop that. It's not going to be stopped by a man from Seshego. I can't vote everywhere. I only vote in one voting station. You have to say it's enough. You want mud schools, Eastern Cape. You want a place where children literally are dying, they are being buried, are dying of hunger, Eastern Cape. Everything that is wrong is happening in Eastern Cape. And they call it a province of legends, correctly so. It's a province of Nelson Mandela, Winnie Mandela, O.R. Tambo, Chris Hani, Govan Mbeki, Thabo Mbeki, you can count them. Yet, service delivery doesn't reflect the struggle credentials of the Eastern Cape. So you must say, we are not like our gogos. We have honored President Mandela. President Mandela is sleeping. Let him sleep in peace. Oscar Mavuyane doesn't look like President Mandela. I will not vote for Oscar Mavuyane. When they say to you, vote ANC, you must say, you are saying I must vote for Oscar Mavuyane, a crook of note, a person who steals education. We grew up being told that no one can steal a qualification. Oscar Mavuyane, masters, stolen like pampas. So you in uniform, go to Oscar Mavuyane's office, arrest him. That University of Fort Hare, it needs a special attention. A lot of ANC people are graduating from that University of Fort Hare, and majority of their qualifications is fake qualifications. So we need an SIU report on the qualifications of Fort Hare. Most of these people of the ANC in Eastern Cape are going to be exposed that they are not friends with books. So fighters, you love books. That's why students vote for you in the universities and TVET college. Tell the people of Eastern Cape and say to them, you love books. They must start electing people who love books, because education teaches you discipline, but it also makes you to be ashamed. When you are not educated, you don't get easily ashamed. That's why they are not ashamed of stealing money from the people of Eastern Cape. So we must restore the dignity of the people of Eastern Cape. We must honor Nelson Mandela in his grave by removing the ANC. He said so himself. If the ANC does to you what apartheid did to you, do to the ANC what you did to apartheid. That's not me. That's Nelson Mandela himself. We want to thank all of you for your discipline. You have been here for too long. For sure your home misses you. But your discipline displayed a day before yesterday and today, no organization can match you except ZCC or maybe Shembe in KZN. No one runs a well-oiled machine like the EFF. The discipline we see in the EFF is too much. And the men of the EFF respect their women. I never had any woman, are you touched by mistake? Because you were all in the stadium the whole night. No single incident was reported. So it is only because of the ground forces. If we were not disciplined, we were going to hear stories last night. We did not hear stories, nothing. And like I said to you yesterday, it's not only you. All the provinces have got the similar thing. They've been sleeping at stadiums, in the halls, and praying and toy-toying. There is no single incident, including with the police. The captain of the police station here, the station commander, we worked with him very well. And where they had a problem, they approached our SG, they raised whatever issue, we fix it, and we proceed. The organization that is disciplined at night and during the day, where do you get such organization? You will never find it anywhere. So if you can be disciplined now, before you get into government, imagine in government, they are going to have disciplined people managing their budget. Like we are managing the budget of Gauteng. The MEC of finance in Gauteng is EFF. So the monies are being controlled by the EFF. We want the same thing here in Eastern Cape. If Nelson Mandela Gqeberha doesn't bring the results, those who are in Gqeberha, including the one I found here singing, they must account. Because we want that municipality. That municipality, that metro is ready for the EFF. And if we lose, it's not the masses, it's the leaders who didn't get the masses to vote for the EFF. So the leadership must take the full blame. Even here in East London, things are ready. In Umtata, things are ready. They are waiting for you. Seated here in front of me is mayors and councillors. It's only you who decide if you want to become a mayor or you want to become councillors. So the power is in your hands, and you have shown it with your discipline. Go and show discipline in the polls. Let's go and mobilize our people everywhere and say, let's go and vote for the EFF. We thank the cooperation of the police. We thank the cooperation of EMS. We thank the cooperation of the leadership of the province and the leadership, the commissars who are here, who are responsible for everything. Vuyani, I'm told Vuyani was responsible for the food. Did he deliver the food? Yeah, I was doubting, or this tall man is not going to give our masses food. So even now, when you go home, the takeaways, you know, you collect and go home. And when you give them takeaways, SG, do not be ashamed. Don't do it in secret. It's only African that when you have visited us, we must thank you. And we can't just say thank you. If I come to your home and I tell you that I'm about to leave, or no, what do you mean? I'm telling you I'm about to leave. The response should be, no, sit, we are about to dish now. So you can't just say, no, oh, bye-bye, bye-bye. Unless you don't love the people who visited you. If your mother doesn't like your friend, when it's time to dish up, she doesn't dish up. She just sits from there, she looks at the time. But if they love your friend, when the friend says, I'm leaving, but Talapans, we are about to dish now. Wait, you can't leave before you eat. It means they love your friend. But the day you hear your mom saying, they don't, this one they don't want. But we want you, and we want you to collect your food, peacefully get into your taxis, and go back home. If a driver is not driving properly, you must not be scared to tell him that you are not an experience. Do not overtake on a burial line. Say, we are people, and if we die, it's a 15 of us, 15 votes of the EFF gone. So stop what you are doing. We've got appointment with the elections. Drive properly. And if the drivers feel tired, they must stop. Don't rush them. Don't fight with them. Be disciplined. I want all of you to arrive home safe. Because what we saw on June 16 in KZN, where a bus killed our fighters, 11 of them, coming from a rally of the EFF, overtaking on a burial line. So we don't want a life lost, especially of the volunteers who come from a rally of the EFF. DOR, we want to thank you because we know many of you are not from here. You come from different areas, but you have secured the fighters throughout the night and during the day, and you made sure that you deal with agent provocateurs. So we thank you, DOR, and we know that you are not being paid for doing this job. You do it because you love fighters and you love the EFF. So we are very grateful to have the volunteers like yourself. When you drive back home, please drive safe. Make sure the drivers, they deliver you in your respective places in a safe manner. We still want you the following day to come and look after us. The media communication of the EFF, you were on par. When the media tried to distort the judgment, you were quick to correct them, and you projected the whole thing live from our own YouTube as the EFF. So we are no longer relying on, what is that thing? Newsroom. We are no longer relying on news toilet to see the news. We now have our own cameras. So EFF communication, mark them, especially news toilet, mark it, because it likes reporting nonsense about the EFF. They call a leader of the ANC Youth League to come and analyze the EFF. This person on his social media, he's got a business card that says he's an NYTT of the ANC Youth League. They call him and say he's an independent analyst. Newsroom, they do that. When you challenge them that this is toilet, it's no longer news, they say, no, the EFF is threatening the media. We take out all the pictures, the posts, and the business card of the so-called independent analyst. Till today, they have not apologized. That they called a politician masquerading as independent analyst to come and insult the EFF. When we challenge them, they say, we are challenging the media. We are not challenging the media. We are challenging people who are biased and who don't give the EFF the right of reply. When you call the ANC, tell the nation that you are calling the ANC to analyze the EFF. Next time, also call the EFF to analyze the ANC. It's only fair. Why are you hiding it? So members of the media who are reporting truthfully, don't be affected by what I'm saying. You know it's not directed to you. But if you feel like it's directed to you, hey, I mean you. If you are right, don't doubt. I'm referring it to you. But if you don't feel anything, then you know you are safe, Shem. You know you are reporting safe. Mara, the shoe. If the shoe fits, you must wear it, especially when. So fighters, we thank our parents who are here. My aunts are here. Let them come and wave at you. If I say they must speak to you, they are going to start crying. Yeah, these are my aunts. They were born with my mother. These are the younger sisters of my mother. We thank them. My grandfather is here. So they think my grandfather is a traditional healer. It's not a traditional healer. It's an old man in the family. So when you see him talking, he's not using muti. It's praise singing. We're praising ourselves. We can't be praised by whites. So this is my grandfather, Malema. So when you see him, you must know, oh, even the old man is here. So thank you very much for coming. Bashabi, Batamela, Balabon. So Malema, they belong to a clan called Bashabi. Bashabi, they are black Jews. So that's why we are people with money. So when you see people, you must know. So if they say someone Mushabi, it means you must start talking about selling. Mushabi means selling. So they were known in the olden days to be selling. The discovery of gold in Mapungube was done by them. Then they took gold and exchanged with the Asian nations because they were trading. So by Shavi, they are traders. If you have a chance and you ask each one of them, do you have a shop or something? They all have something. Either spaza shop, or they are selling a snake, or they are selling meal, because they're always trading something. So these are our family as well. Thank you very much. Bye-bye, Mr. Maja, Batamela, Aperta Lama Felelo, Laela, Lem Mamaya. This is my father. I get like to but Waba adopt Tabana. So Naga adoptile Papa. This is my father. Maja, Lamusadia. They've been supporting us. Ralelabua, Relgamoso, Ndonkulu. This is my wife. And then where's Rati? Kimukise, Mazakise. Ratu guy. Voice, you wanted to say something?
Amanda. Long live President Julius Malema, long live. Long live President Julius Malema, long live. Thank you fighters for the support. Thank you.
And then this is Ratana Malema.
Amanda, viva EFF, viva. Long live the Commander-in-Chief, Julius Malema, long live. Down with Africans, down. Down with this name, down. Down with de Klerk, down. Down with this racist magistrate, down. Amanda, away, two.
Thank you very much. Sitle, where's the Naledi? Come, Sitle. The convener of the Youth Command. Amanda! Kawe! Two! Long live the EFF Youth Command! Long live! Long live the EFF Youth Command! Long live! Futek AfriForum! Futek! Futek AfriForum! Futek! Thank you, President.
Amanda! Viva EFF, viva! Viva EFF Youth Command, viva! Amanda! Futek Donald Trump, futek! Futek DA, futek! Futek AfriForum, futek! Futek! Amanda Lagas.
Mandla. Thank you very much, comrades. I think I've thanked everyone. Our friends are business people, so if we bring them over here, they are going to close opportunities for them, but they are here. They are the ones who have been supporting the EFF. This one things I forgot. He says, I must tell you, Mail and Guardian is supporting the EFF. Thank you, sir. So, our friends are here. We can't call them on the stage. Otherwise, the state is going to lock opportunities for them. But whatever you see happening, especially with buses and T-shirts and food and they've been supporting. We want to thank you, all of you, our comrades in business and our friends who are here, who have supported us until this far. And then we want to thank the CCT. Members of the CCT, there are too many. There are too many, unless they are here and they come running to come and wave. CCT, if you walk to the stage, don't come. But if you can run. Run to the stage. Whoever is close of the CCT, not all of them can come. The leaders of the EFF are here. Just wave at them. These are your leaders. These are your leaders. CCT is Central Command Team. They are responsible for the EFF all over South Africa. Some of them, I see them there, wave, wave, wave. Hello, 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 hello. We can see you leaders. Thank you very much. Thank you for your support. Thank you very much, the leadership of the EFF, National Chairperson, DSG. We want to send the special thanks to our Secretary General. We now have a Secretary General who knows what the Secretary General must do, and he does it very well. He doesn't get conflicted. He knows what is expected of him, and we thank him. He's the one who pulled all of this all over South Africa. We thank the comrades in the TGO, especially TG, for paying for what the SG organized. It's not easy for the SG to get something from the TG. Sometimes the SG has to call me and say, talk to her, she's refusing to pay. It's that kind of a relationship, because the SG wants more and the TG has got less. So they fight, but they work together to make all of this happen. Please, let's give them a round of applause for being disciplined and united leaders of the EFF. All the security guys who are here looking after everyone, including our legal team, we thank you very much. Legal team, you have done a wonderful job. This is not the end, but the beginning. The fight goes on, and we are ready. We were born ready. All of you, thank you very much, and thank your families for us. Amandla! Amandla! FIFA, EFF, FIFA! Down with AfriForum, down! Down with Malan, down! Down with Verwoerd, down! Down with Botha, down! Down with de Klerk, down! Amandla! Amandla! Oh no, Makubi! Siyaya! Siyaya! No Makubi! Siyaya! Siyaya!